Take any date here, Lord.
34 and 35.
35, yeah.
Okay.
Next take any date.
On the pair being met by Mr.
Next is.
Islam,
Lord.
learned counsel for the appellant in item number 34 and respondent in item number 35. The matter is then adjourned to be listed. Mr. Islam, this in this,
Already hearing concluded, we have to submit.
yes, you have to produce the
Lord, I am
judgment.
searching here.
You
Next-
produce the judgment. When?
Next date, in Monday or Tuesday. Fix.
Tuesday, hearing day.
Lord.
Bless.
Yes.
25th. Okay, I'm praying for listing of a contempt also. Next week.
When?
Next
One time you go and mention before the senior court. Court number 4.
week.
Yes,
Mention for listing a matter for motion, Lordship.
go there.
Obligation.
I think some vacancies for today.
Pardon?
Item number 4.
Item number 4. Yes.
Lordship, I'm for the petitioner, Lordship. We have some urgency, Lordship. Initially, we objected also, but if it's only for the day, Lordship, then that case, no problem. Lordship, I prefer fix it, Lordship.
When? When do you want?
Friday or Monday.
Friday or Monday? Friday may not be possible or a lot of cases have been fixed. On Monday,
Wednesday.
Wednesday.
Lordship, can we on Monday, Lordship? It's not
Monday.
very inconvenient, Lordship.
Let's get this. Okay.
Okay, Monday.
Lordship,
On the
deeply
pair being made by Mr. Your name, please.
That's
Learned counsel for the petitioner or respondent.
not 4.
Respondent number 4. The matter is then adjourned to be listed on Monday.
24.
Yes.
Deeply obliged, man.
May I please, Lordship, with the consent of other side, my lord, I beg to mention item number 26, my lord. Possible for a day only, my lord. Something which-
26.
My lord. For a day only, my lord. Repeatedly.
Mr. R. Sharma, learned counsel for the petitioner with consent from the other side, thus for listing the bread for adjournment of the matter for the day. Pair allowed. Matter is then adjourned for the day.
Item number 27.
27.
Second concern of the respondent, Lordship. If some instruction needs to be obtained from the client, Lordship. So, matter may taken up after 2 weeks.
After 2 weeks.
2 weeks.
Mr. Towilder, learned counsel for the petitioner with consent from the other side, thus for listing the matter after 2 weeks. Pair allowed. Yes.
Okay.
Please, Lordship, item number 3, adjourn for the day, Lordship.
Item number 3.
Yes, Lordship. Consent from other side, Lordship.
Miss, your name, please.
A Khatun on behalf of Amir Islam.
A.
Khatun.
Learned counsel appearing on behalf of
Adjourn for
Mr.
2 weeks, Lordship.
S. Alam.
A is M Islam.
M. Islam. Learned counsel for the petitioner. With consent from the other side, press for listing the matter after 2 weeks.
Yes, Lordship.
They are allowed.
I beg to mention item number 32.
30?
32.
32.
This case I have filed an affidavit that is not in record matters. Can be taken on next week matters.
Okay. On the pair being made by Mr. M. Kolita, learned counsel for the petitioner. With consent from the other side, the matter stands adjourned to be listed on
Next week, madam.
28.
28.
May I please, Your Lordship, I beg to mention one writ petition. It's regarding non-payment of salary. Can it be listed on 24?
You go to court number 4. That is senior court.
Items for admission. Item number 1, partner meeting. Next day, Lordship. Last one, in fact, the hearing was almost good. But only thing the Lordship has directed me to problem in writing was that what are the criteria that becomes by the petitioner? And the director has already written to the secretary, and the particular instruction is avoided Lordship. So may I prefer fixing the matter on Friday, this Friday, Lordship. Perhaps by the time we will receive that written instruction. As to what are the
You
criteria.
see, if you fail to produce it on Friday,
Lordship.
then we will conclude the argument and
Yes,
we
sir.
will
Yes.
pronounce the judgment.
Let him produce, my lord.
Heard Mr. Abedin, learned counsel for the petitioner, Mr. P. N. Sharma. Learned Standing Council for the Elementary Education Department. Mr. Sharma submits that though he was directed to produce written instruction in respect of the criteria which the petitioner did not meet, yet he submits that the director has written a letter to the secretary and the response is still awaited, and a place for listing the matter on Friday were allowed. In the event of failing to produce the written instruction, the court will conclude the argument and will proceed to pronounce judgment.
Item number 2, further matter. May it please, your lordship. This matter relates to lordship overstaying service, and the petitioner was working as an associate professor, lordship. And
Overstay in service.
overstaying service, lordship.
Mr. Das, you have filed your
Yes, sir. Fine, lordship.
affidavit. So already we have heard the matter,
Partly hard.
partly. For how many days or months or years the petitioner remain overstayed in service?
11 months, lord.
11 months.
11 months.
So what is the reason for why staying in service?
Lordship, the petitioner is actually has no knowledge about his retirement age, lordship. No, at
No
first,
knowledge about his retirement
no,
age.
because he was a teacher, lordship, actually, and he was busy in teaching the students only. He was not concerned about his retirement, lordship. He came to know about his retirement only on 13/12/2021, lordship. Annexure 1 document, while a communication has been made to the petitioner, lordship.
Came to know only on
13/12/2021.
13/12/2021. And in the meantime, you have overstayed for 11
No, this is a
months.
communication regarding information of his retirement date. 30th April 2022 will be his retirement date, lordship.
30th April.
Lordship.
Who had furnished this information to you?
The principal of the college, lordship.
That letter is part of the record.
Lordship. So
Page
Annexure
number?
1, page 17,
17.
lordship. Read petition, lord.
Okay. Thereafter,
Thereafter, lordship, another letter was issued on 30th of December 2021, intimating that the date of birth of the petitioner is 15/1/1961 instead of 1/4/1962, lordship. Hence, his services has been discontinued with effect from 31 January 2021. Lord. Annexure 2, page 18, lord. It is informed that, lordship, during the time of preparation of your pension paper documents, it has been detected that your date of birth was so and so. First paragraph.
Mr. Fukon,
Lordship,
the petitioner herein is a professor.
lordship, associate professor while he was on in the time of retirement.
Is it believable that he did not know about the date of his retirement? Is it believable?
Lordship, because he was a, his person is that he was a teacher, Lordship. Mainly,
Maybe.
Lordship. He is mainly involved in teaching, Lordship. So he perhaps, anyway, Lordship, then my lord, he, the annexer 3 document, he intimated the principal, Lordship, that citing his, the ill health of his wife, Lordship. May I read the Lordship annexer 3 document, Lord?
What is the stand he had taken therein?
That his ill health of his wife and ultimately his wife died because of liver cirrhosis. And that is the reason that he did not give him space for superannuation affairs, Lordship. The stand taken, Lord. First paragraph, may I read, Lordship?
Not necessary.
Lordship. The now he has taken, Lordship, he has no knowledge about his superannuation date, Lordship. And my lord, mainly, my lord, my humble submission is that service book is generally prepared by the office of the principal, Lordship. Your Lordship, there is a defect in the service book regarding age, Lordship. And Lord, they have also the respondent number 3 and 4 has submitted an affidavit, Lordship.
E and 4 have submitted their affidavit.
Affidavit, Lordship.
What is their stand?
They have also given the Lordship one extract copy of the service book, page 23, annexer 6. Annexer 6, page 23, in vernic English, it is date of birth by Christian era is nearly as can be retained, Lordship. Here it was written 1/4/1962. The signature of the principal, Lord. And Lord, prior to that, Lordship, they have also taken the standard, Lordship. In the standard form of application, I have wrongly written my date of birth, Lordship. This is a version of the respondent number 3 and 4. Lord. They have also annexed 2, 3 standard form, Lordship, wherein I have mentioned that I have mentioned different date of birth, Lordship.
Yes.
Lordship. Regarding their standard, I have written different date of birth, Lordship, in my standard form of application before the college authority. My humble submission is that this is not a misrepresentation of my date of birth, Lordship. It's actually not a misrepresentation, Lordship. Regarding my date of birth, Lordship. It's actually miscalculation. If your Lordship kindly will go through the admit card, HSLC admit card, which they have next service, Lordship. Page 35, Lord. The Board of Secondary Education, HSLC certificate, Lords. Here, Lordship, the confusion arises perhaps from this document because Lord, here date of birth has not been written. Here, Lordship, age has been written, Lordship. At the relevant point of time, age is aged 16 years, 01 month, 16 days, Lordship. Perhaps due to miscalculation, Lordship, this date of birth has been written like that, Lordship. Generally, in our time, Lordship, we have seen that, Lordship, the exact date of birth has been written, Lordship. But here, Lordship, only age has been written. 16 years, 01 month, 16 days. If it is calculated, then the date of birth is, this is 15/1/31, Lordship. Not
The date which you have entered in your standard form,
Lordship.
that is the date,
That is the reason, Lordship.
as per this certificate.
No, as per this certificate, there is a miscalculation for which the wrong date of birth has been given, Lordship. 1/5/1962, Lordship. Because, my lord, from this, Lordship, we have to calculate to find out my age, date of birth, Lordship.
Then,
Because of that, Lordship, that may be, Lordship, a miscalculation.
no, what would be the exact date of birth as per this certificate?
As per this certificate, Lordship, 1961.
15/1/1961.
1961, Lordship. But in the service book, it has been reflected as 1/4/1962.
Then you have miscalculated the date.
Lordship, and even also, my lord, college health authority has also miscalculated this, Lordship. Because, my lord, the SSLC certificate is always there, Lordship. I have not submitted thereafter, Lordship. It is from the beginning, Lordship, in the record of the college authority, Lord. I have not misrepresented anything. I have not submitted anything wrong document, Lordship. It's my submission is that, well, perhaps it's a miscalculation, Lordship.
Now, what is your prayer in this petition?
My fear is that already a communication has been made to refund an amount of rupees 21,94,630, Lordship. And so far, my information concerned, Lordship, perhaps this amount has already been recovered, Lordship.
Already been recovered.
Recovered, Lordship. During the pendency of this restriction, Lordship.
But are you getting the pension now?
Pension I am getting, Lordship.
Okay. Yes, Mr. Das, the
My
amount has been
house
recovered.
is quite covered by this apex court judgment, Lordship.
Which one?
This is 2009 CSCC 117 Jagadish State of Bihar and others versus Pandey Jagadish Prasad.
Which paragraph you have relied upon?
Paragraph 24, 26, Lordship.
Okay. Paragraph number 20.
24, 26. Paragraph 25 also, Lord.
Yes, Mr. Das.
What is this number? I filed affidavit, Balas, and you have page 54 of the affidavit, Balas. Here, madam, what is happened, earlier, the service proved the date of birth of the petitioner was written as 1/4/1962. And on the basis of that, the college authority has intimated the petitioner regarding his date of superannuation, madam. Then, madam, for pension preparation of pension papers, when the documents were verified, submitted by the petitioner, then the college authority found some anomalies for us. The anomalies are, I have mentioned in page 54, ma'am, in my appendix.
mm,
Para 6.
mm.
Hello?
Hmm.
As per HSLC certificate, his date of birth 15/1/1961, which is the correct date of birth, my lord.
Hmm.
Then, B. The petitioner himself once submitted one standard form. Which is a self-declaration. There, the petitioner himself wrote his date of birth as 1/5/1962. Then, my lord, C, another self-declaration where the petitioner has written his date of birth as 1/1/1963. Mother, he is a teacher. And for a teacher, my lord, it is hard to be believed that he doesn't know about his date of birth. Forget about the wrong.
No, Mr. Das, the contention of the petitioner is that he has enclosed the SSLC pass certificate along with his standard formation. So, are you not obliged to, are you not bound to go through the same to check the actual date of birth?
At the time of recording his date of birth in the service book, madam, the initial problem is in the service book. In service book, whether madam, the authority, college authority has recorded rightly or wrongly, madam, it is have to be madam, submitted whether at that point of time, whether the petitioner influenced that authority or whether the authority themselves madam, note down a wrong date.
No, no.
madam. But, my lord, what I want to show is the conduct of the petitioner. He himself on various dates, my lord, when he was required to file, submit standard form self-declaration, he himself, my lord, given wrong dates of his date of birth.
Hmm.
And
No,
documents, my
okay,
lord.
he has given a different date in the standard form, but he has enclosed the certificate
Yes, my lord. So,
where the date of birth is, no, where his age is indicated.
age is indicated. No, my lord, in HSL certificate, my lord, there
Age is
Age
indicated,
is indicated.
yes.
It's not the date of birth. my lord.
So is it not your duty to check the date mentioned in the certificate and the date mentioned in the standard form?
But it is the college authority, yes, it is the duty of the authority to incorporate the correct date of
Correct
birth.
date of birth, yeah.
My humble submission is that will not give a right to the petitioner to.
No,
say,
no,
yes, ma'am. And
the,
moreover, my
no.
in this case,
no, that's
he has
all
been
right.
asked to.
Mr. Das, you say, so can it be said that he has misrepresented himself or he has committed any fraud?
Malad committed in the fraud, I want to show that from thereafter, Malad, after recording his date of birth in the service book, thereafter also the petitioner himself has submitted different various dates regarding his date of birth.
Hmm.
Malad. Had, so this shows that, Malad, that he has, Malad, tried to trying to mislead the college authority regarding his date of birth, Malad. In
Hmm.
fact, in this petition also, the petitioner never said that the date of birth mentioned in the HSL certificate is wrong or right, my lord. It is not the case of the petitioner that the college authority has wrongly calculated his date of birth. Nothing in this petition, my lord. And when the college authority found those anomalies in his documents, my lord, college authority asked the petitioner to submit the documents to substantiate his claim regarding the date of birth mentioned in the service book, which the petitioner failed to submit any documents, my lord. Then,
No, Mr. Das, you say service book is prepared and maintained by whom? The college authority?
authority on the basis of the documents submitted by the petitioner.
He has submitted his SSLC certificate there,
Yes, ma'am.
though he has miscalculated the date of birth in the standard form. Hmm.
My lord,
Can it be, can the misrepresentation or fraud can be established from this?
my lord,
Because original, the certificate, he has enclosed with the petition.
And
application.
include the petition, Malad, and it is, my humble submission, it is the duty of the petitioner also to verify, Malad, whether his what will be to determine age and whether this service book has rightly or correctly maintained by the college authority. And well, kindly to me, regard on a where there is a dispute between date of birth,
Mm.
I want to submit one. Decision. Decision, Madam. This. This is a judgment of this court and authority, court and bench, my lord, where the honorable court has mentioned several judgment. My lord, I'll be relying upon on there are 19. And I'll read.
There are 90.
There are 19, 20, 21, and 25. my lord.
Mm.
Here also, my lord. It is, may I read, my lord, in from para 19.
Mm.
In case of MP and others versus Mohanlal Sharma,
Mm.
reported in so the Supreme Court has held that the date of birth recorded in the matriculation certificate carries greater evidentiary value than that contained in the certificate given by the retired headmaster of the school or in the household. In the case of so, the Supreme Court has held that the date of birth mentioned in the matriculation certificate should be treated as the date of birth. It is further held that it would be open for an employee to place other documents before the authority to prove that the date of birth shown in the matriculation certificate was correct. It is number 20 from the above provisions of the Supreme Court and this court. It is clear that besides the date of birth, the date of birth recorded in the matriculation certificate should be one of the first documents to be relied upon by an employer for determining the date of birth of an employee. The date of birth recorded in the matriculation certificate carries far more weighted than the date of birth recorded in other documents in absence of a birth certificate. In any event, the date of birth in a matriculation certificate can also be challenged by a person, but that will be not included. Then there are 21 in case of so reported in 1977, 4 to 5, the Supreme Court reiterates that another of its decision in the case of so holding that it could no longer be disputed that the state is not precluded merely because of the acceptance of the date of birth of its employee in the service register from holding an inquiry if there exists sufficient reason for refixing this date of birth. In the present case, the date of birth recorded in the petitioner's service book had only been made on the basis of an affidavit made by the petitioner's brother. So what is, my lord? From those judgments, my lord, it is the observation made by the Supreme Court that it is the matriculation certificate, the date of birth mentioned in the matriculation certificate from which
No, that's all right. There is no dispute about it. He has also not disputed it.
Yes, my lord.
Mm.
Now my submission is that, my lord, the date of birth mentioned in the service book, it has no value, my lord, for calculating the superannuation age. And my lord, in Supreme Court also says that the authority or state is not precluded for refixing the date of birth, the basis of the certificate, HSLC certificate. Even if the date of birth mentions.
No, the petitioner has also no, Mr. Das, you see, the petitioner has also no objection in refixing his date of birth. His question is this recovery. He has relied upon paragraph number 24 and 26 of the decision of Supreme Court in Pandey Jagadishwar Prasad case. So what is your submission on this point?
My submission would be that the self-declaration form which was submitted by the petitioner. From there only, we can see the manipulation or the petitioner's contention to mislead the college authority regarding his date of birth. That would be my.
No. If he had not enclosed the certificate along with his application, then there was a scope for making a contention that he has misrepresented. But while he has enclosed the certificate where the age is mentioned, then can it be said that there is any misrepresentation or fraud?
We have to see the whole conduct of the, in my humble submission, we have to see the whole conduct of the petitioner. At that point of relevant point of time, when his service was maintained or the dates were incorporated there. Don't know whether at that point the authority was influenced by the petitioner.
No.
or
On
not.
what basis you were submitting that he had influenced the authority? Is there
That's
any
what-
basis?
No, that's why I'm saying. that
No,
we don't
only
know.
on
We
presumption you
we
cannot.
don't know at that time what had happened, but kindly see the subsequent development manner. Subsequently, the petitioner himself has tried to mislead the college authority by showing different date of birth, and he's a teacher manner.
No, where he has shown? In which document?
It doesn't, one of the documents are annexed by the college authority.
Page number?
Kindly have the affidavit filed by the college authority, page 37.
Page 37.
Page 37 is the standard form of application. of the college.
Mm.
And I thought,
Mm.
I think page
38.
38.
38 is the, yes.
Point number 9, my lord. This is the standard form of application.
No, he has already stated that it is a, yes, that is incorporated by him.
This is one document, my lord. Next is can you see the below, my lord? There is also declared that in case of any false statement, I am liable to any action government may deem fit and proper. The last line, my lord, in page 38. Then kindly have next page. Page 39, my lord.
Kindly go to page 38.
42, my lord.
That your date of birth should be. You know, Lordship, page 38, he has not mentioned about the date of birth, Lordship. He has just age, Lordship.
That's what, if we calculate that, his declaration, my lord, it would be, the date of birth would be on 1/5/1962. Then can you have page 43, my lord? It was the letter written by the petitioner to the principal in the year 1991. Then at page 43, here, the date of birth written by the petitioner is 15th of February 1962. And he says that it is as per HSLC certificate
Enclosed.
enclosed. Then my lord, kindly have page 46, my lord, page 46. Page 46. It is also a standard form of application submitted by the petitioner before the college authority. Here, point number 9. Age is on the 27 years.
Age, he has written age,
If we
Lordship.
calculated the age, it will be 1/1/1963.
But Lordship, he has written that age on 27 years, 1st January 1990, Lordship.
Hmm.
But there's must be some basis for writing those sentences, my lord.
Hmm.
As on 1st January 1990, Lord.
That is my humble submission, my lord. That this source is the content of the petition that it is trying to mislead the college authority regarding his date of birth and and when there is uncertainty regarding the date of birth, the document the value of the SSL certificate will be carries more value, madam.
Hmm.
And the state government is not precluded from refixing or taking action to that in regard to that.
Okay, refixing, we have no
So
objection.
in the
Lordship.
meantime, the amount has already been recovered.
Recover. During the pendency of the retention, Lord.
Now what remains to be decided? Only the recovery part.
Lordship.
But you say in the standard form, you have given one undertaking, making yourselves liable
Lordship.
for any mistake
It is also a case, Lordship, but
in the
every
declaration
Lordship,
made in
it
the.
was mentioned that Lordship
Hmm?
as per matriculation certificate and close. And moreover, my lord, if you go through this standard form and their affidavit,
Hmm.
there is another aspect. Lordship.
Hmm.
I'm submitting, Lordship, kindly have a look at page 27,
Hmm.
paragraph 3, point number 11, Lordship. The petitioner Sri Prince Bhuya joined as lecturer in education against the lien
Paragraph
vacancy.
number
Paragraph 3, Lordship, 3 and Roman 1.
of the affidavit of.
Affidavit filed by respondent number 3 and 4, Lordship. Page 27, Lordship.
Yes.
1 Lordship, the petitioner Sri Prince Bhuya joined as lecturer in education against a lien vacancy on 21/3/91, and he worked in the post till 31/8/1991.
Hmm.
Lordship. And secondly, the petitioner thereafter appointed as lecturer in non-sanctioned post by the college governing body on 1/9/91, and he worked in the post and worked till 20/11/1994.
Hmm.
3. The petitioner Sri Prince Bhuya is appointed as lecturer in education against the sanctioned post on 21/11/1994.
Hmm.
These all standard form relating to his lordship, his temporary engagement, lordship. What about this permanent engagement? What he has submitted, lordship? Some document has to be submitted, lordship,
Hmm.
for appointment against a sanctioned post, lordship. There is no document, lordship.
Hmm.
And in the all these documents goes to show that, lordship, these are miscalculations, because he has written 3 dates, lordship.
Hmm.
Why he has written 3 dates? There is a miscalculation on his part, either by him or by any other authority, lordship. Even my
No,
lord,
no, it can goes in both the way.
lordship,
It
that
may
is right, lordship.
go, it may goes against you also.
Lordship.
Why 3 different dates?
And that is, lordship, I am submitting that
Hmm.
perhaps it's a miscalculation on part of.
Yes,
Because of-
what is the stand of the college authority? Hmm.
Here, all the different dates, he mentioned is different dates.
Hmm. But why the standard form, date mentioned in the standard form
And
Has
in the
not been
standard form, he
take
has already declared.
in the light of the SSLC certificate enclosed by him with the application form?
No, actually, what happened, actually the certificate they didn't find, even they have asked him to produce the certificate, he never produced it. At the last stage, he produced it.
No.
At a
At the
different
time
day.
at the time of filing the application, he has not enclosed the.
And
Certificate.
The certificate.
Is it correct position?
That has already been stated in para 3. We have stated in para 3
Hmm.
the entire history, your lordship.
Para 3.
Yes. And para 3 of 27,
Para 3 page number. Where you have mentioned it?
Page 29, your lordship, come to D. The respondent under such circumstances are the petitioner to furnish valid documents which can be substantiate proof as per the recorded date of birth of service book. So that pencil paper could be proceeded for onward submission to the concerned authority. The petitioners could not furnish any document as proof of the date of birth as per service book 1462. The respondent number 3 has no other option but to take the date of birth as per HSLC.
No, no.
Yes.
The petitioner's contention is that he has filed the SSLC pass certificate along with the application form.
Yes.
What happened to that certificate then?
Now, he is a responsible man. He is a master degree qualified. If he mentioned the date of birth, then it is presumption that we take as the qualified person. It is correct one. The college.
No, whether how you have discharged your duty? How you have prepared the service book?
At that point of
No,
time.
no, you explain me how you have prepared the service book?
That has been corrected later on, when we came.
No,
to
no,
know.
at the time of,
Yes.
no, at the initial time, while this service
As
book
per
was
the
prepared.
statement in the standard form,
Hmm.
the service book was prepared. If he put the wrong information in the standard form.
No,
then
he has, no.
misrepresented this thing. out.
Mr. Upadhyay, you say, his contention is that he has enclosed the certificate along with the standard form. Why did not you check the same
Now,
to verify the date mentioned in the service book?
because he is a qualified person,
No,
whatever is stated,
no.
it
You
is correct
cannot,
one. The presumption
Mr.
is there.
Mr. Upadhyay, you
And
cannot,
he is an associate professor.
maybe,
He should have write the correct date
maybe,
of birth. Correct date of birth.
maybe. Being the authority, you are also
Nobody
not supposed to.
Nobody disbelieve a professor.
Hmm.
Nobody disbelieve. Whatever age they have said, at the last stage when there is discrepancies at the time of preparation of pension papers, then these discrepancies comes.
Okay. We'll pass the order.
Lordship, I
So the
just,
amount has been recovered from his pension, entire amount.
Yes, that's correct.
We'll pass the order. Decision পাঞ্জাবৰ জুডিচিয়েল অফিচাৰ আছিলে এডিচনেল আছে ইয়াত আৰু সেই জাজমেণ্ট অফিচাৰ DY চন্দ্ৰচূড় দিনৰ আগতে দিলোঁ আমি ইয়াতে মাতি দিওঁ। Okay, we'll pass the order.
Yes, here, my submission is here, another problem is that in the admit card, it is not mentioned the date of birth as such and such. It is mentioned on the 1st of March, his age is, that's why the clerk has not checked it.
No, you cannot take that stand. It is.
He has declared, so
It is
there is
impermissible.
no question of disbelieving that.
No.
person. He is associate professors.
Hmm.
He is declaring his wrong age. He cannot say that
No.
that is miscalculation.
If I
Cannot
abdicate, if I have abdicated your duty, being the authority.
At that time,
Okay, all right.
obliged. Further number 5, parted matter.
What is this the DP is pending now?
Lordship, the new development arise as he has been terminated.
When?
A letter we have received on 18/11 yesterday.
Yesterday. So
And
the
he has
disciplinary.
subsequent- As per Lordship order,
Hmm.
the inquiry committee was constituted
Hmm,
and his subsistence allowance has been released.
hmm.
And that committee, after inquiry, the report has been.
Whether he had participated in the report or no, in the inquiry proceeding.
Lordship, he has participated.
Participated.
Lordship, I want to place this also, in the inquiry report. It's over now.
So, Mr. Bora, the Council for the Respondent Authorities has produced on termination order.
We
The
have not received
petitioner is
any,
terminated.
we have not received any communication regarding termination, Lordship.
You have not received. So whether your petitioner had participated in the departmental proceeding? in it?
Lordship, one show cause notice dated 4/10/2025 was issued to him on 14/10. And when he appeared before the committee, he was asked to file a written statement and he filed his written statement.
Yes.
But thereafter, no communication was.
Better you do one thing, madam, can you furnish a copy to him?
Lordship, may I,
Yes,
I
Lordship.
mean, let him obtain instruction
Lordship,
Next week.
next week.
Lordship.
Heard Mr. Bora, learned counsel for the petitioner, and also heard,
No photo.
madam, your good name, please.
Sir.
S. Tongwa, learned standing counsel for the PWD. During the course of deliberation, Ms. Sharma has produced one termination order dated 18/11/2025. And she's on the basis of the same, she submits that a departmental proceeding was drawn up against the petitioner and inquiry was conducted, and thereafter the petitioner was terminated from service. Ms. Bora, no, Mr. Bora, learned counsel for the petitioner submits that he may be granted some time to obtain instruction. A copy of the termination order be furnished to Mr. Bora, learned counsel for the petitioner. List after a week on COVID.
If that instruction kept as a recording.
Yes, the termination order and also
Inquiry
the
report.
letter dated 4/11/2025 produced by Ms. Sharma before this court today be marked as Annexure X and Y and be tagged to the record.
Obliged.
Part this number.
Number 6.
May I please your lordship? This is a simple case, my lord. That petitioner 1 to 6, my lord. And 7 to 10 was a gardener. That engagement made my 98, 97, 98. Now my prayer here is, my lord, not even for regularization. Only that a contractual basis they were engaged, whatever, my lord, as per their contract, my lord, that will be paid. That much prayer, my lord.
No, now you are in service or not?
I am in service, my lord, because they are not discontinued. Earlier, they approached the Honorable Court for regularization. Court directed to examine if it's possible. But that has not happened. They are still continuing
Continuing.
as a
And
laborer, my lord.
your salary for the
My lord.
period?
Salary has not paid. Sir, AMI page 13 onwards, my lord. Page 13 onwards, my lord. Appointment letter.
No, for which period you have not been provided with the salary?
My lord, since inception, my lord, not paying.
Since inception.
The page 13 is the first appointment letter, petitioner number 1, in which you kindly go through. As per Education Policy of BSc, page 13. An instruction thereof by letter number so and so dated 9/12. An approval of Director of Education BC Kokrajhar, letter number so and so dated 4/9/96. Sri Daman Sargari, son of so and so, Gotbeta, Assam, selected candidate by the District Secondary Education Advisory Board for BSc area is hereby appointed, engaged to work as the assistant at Golagaon High School in a fixed pay of rupees 1,200, 1,200 per month, date of joining. The payment shall be made from the BSc's funds if available. So it has no responsibility. The Gupta Basam and Inspector of School PDC Barpeta. Engagement shall not accrue any right, exclaim any post, future appointment. Arrangement is purely temporary and terminated at any time and without any notice to the person concerned. So, my lord,
You have
and terminated, unless terminated, allowed to continue.
So
that
you are
whatever-
working since the year
97,
1998.
Right. Yes, my lord, 98. We have given a cert in para, my lord. Making a cert, my lord.
Where is the affidavit of the respondent?
Affidavit file, my lord. Affidavit file, my lord. Affidavit, we cannot claim for regularization. And
No, what about the area salary
area salary,
and current salary?
current as well as area, my lord, whatever.
Lordship, we kindly peruse, my lord, the affidavit, page 51, my lord. Lordship, similar cases were filed, my lord. Because they were against non-sanctioned and non-existent post, my lord. There has been an order from BTC, my lord, to terminate their services on 12/11/2004, my lord. Thereby, they have come challenging that order, my lord. And this honorable court, my lord, the coordinate bench of this honorable court has passed the order, my lord. Order will, your lordship will find that page, my lord. 57, my lord, relevant portions. From 51, my lord, paragraph 12, my lord. May I read, my lord? The BTP authorities have put on record an order dated so whereby a decision was taken to terminate all appointments, including that of the petitioner, which were made in post of non-sanctioned by the government of Assam. Even assuming for the argument what intrigues this court is a long delay for more than a decade in approaching the court. The state issue can also be examined by the communication that is so and so, wherein it has been stated that the petitioner has been discharging in service in the school on honorary basis. It is a settled law that in the provincialized school managing committee does not have any jurisdiction to make substantial appointments. In that case, the petitioner claims to have been appointed in the state school as per order of the inspector. However, as would transpire from the communication, which is supported by the pleadings, that such posts were non-sanctioned by the government of Assam. So, my lord, the claims were rejected, but my lord, lordship, paragraph 14, my lord. However, regarding the payment of salaries, if he is actually serving as permitted by the school managing committee, it is up to the committee to arrange for the funds and to make payments to the petitioner after verifying as to whether he had actually been rendering his service. So my lord, in a similar line, my lord, this order may be passed. My lord. Can be passed. Otherwise, they were, my lord, in working against non-sanction and non-existent posts, my lord.
No, whether any fund is available in the account of the school
Committee.
managing committee.
That, my lord, that instruction I do not have.
No, if the fund is not made available in the account of the school management committee,
Lordship.
then this order is meaningless. Where will, from which fund they will pay the salary? Then why should we pass an order which is impossible to be implemented? Do you think that this court will also undertake the same exercise and pass similar order to frustrate their claim?
Lordship, then allow me some time, my lord. I'll take instruction in that regard, my lord. Whether there is any funds available.
Honorable court's order is annexed here, my lord.
Yes,
Here, my lord, the petitioner claim for regularization. And the next case which rely, my lord, that is they were engaged by the managing committee, not by the authority. In our case, my lord, it was the appointment order issued by the inspector of school. However, there is a clause that BSc authority is responsible, the state government is not responsible, because, my lord, that BSc Act, my lord, section 14, 24, my lord, some regarding grade 3 and grade 4, it is under the domain of the BSc authority. That how they pay, my lord, it is up to them. But yeah, in my case, I am not even claiming the regularization. Only that whatever they, as per contract, I am to pay, my lord. Otherwise, my lord, is bound to a forced labor. Violation of Article 23. And, my lord, the Honorable Court, Supreme Court, in various decision says that when the, my lord, person in a casual manner or, my lord, works as or anyway completed more than 10 years, minimum wage has to be paid by the respondent authority. State of Punjab versus Jagdish Singh, there is a case. So, my lord, I am not even claiming minimum
No,
wage also.
Madam, you see here, the
Madam.
appointment orders were issued by the not by the school management committee, by the inspector of school.
Yes.
Then
Yes, my lord.
At the time of creation of BTAD in that of, my lord, employees, my lord, they this way, that way they engage. There are several cases pending, my lord. Now they have some Christian. Now sanctioned in 2003, other case, my lord. But it's not for regulation, whatever, but they continued with an expectations. Whenever the post will create by this our sanction, my lord, they will be engaged, but they will be engaged or regularized. That was their expectation. That's why they are continued. But even, my lord, that has not done. That's why whatever that contract, my lord, that should be paid. That much, my lord, that BSc authority will pay.
so, madam, how this judgment will help you?
Lordship. The earlier order, my lord, at page 55, my lord, the affidavit in occupant. These were also, my lord, initially appointed by the BSc, my lord. BSc fund, my lord. They were working under a particular scheme, my lord. So these petitioners were also under some, working under some scheme, my lord. I have to verify on that. Because, my lord,
So this order will also not help you because the petitioners of that case were appointed under a scheme.
scheme, my lord, yes.
prayed for regularization. They are also prayed for regularization on that scheme. Well, our prayer is not for regularization.
Yes, so who is appearing for respondent number 1 and 2?
That awesome.
Secondary Education Department. You are.
That's the BTS of authority, they come up with specific instruction regarding payment.
Yes,
The government has not been, it has been clearly stated that it is the BSC authorities that will make the payment. If there is, what is, let them come up with.
No, you tell me whether there is any fund in the school management committee's account, whether there is any account in the name of the school management committee. So if there is no account, there is no fund in the account of the school management committee, then whether this order can be implemented, which has already been passed.
The authorities specific instruction whether the particular part of the payment. So if there is no shortfall, whether there is no fund available, how they are making it, for example, if the petitioner are eligible for whatever they're claiming, then that specific instruction comes from the BTC authority.
No, they have already filed one affidavit.
Director of BTC Malad will responsible in that case, Malad?
Yes, sir.
I think instruction.
A small instruction document, whether it is available, because there will be.
Heard Mr. Goswami, learned counsel for the petitioner, and Ms. Bora for the respondent number. You are for respondent number
BTC.
45.
Fine.
45. And Musahari for respondent number 2 and 6. No, 1 and 6.
And then
1, 3 and 6, inspector of school. Okay. 6 is Ms. Bora. Mr. Soliha for respondent number 2. And Ms. Musari for respondent number 1. 1 and 3. After hearing learned counsel for both the parties, it is provided that Ms. Bora, learned counsel appearing for the respondent number 4, 5 and 6 shall obtain instruction as to whether any fund is available in the account of the school management committee so as to pass similar direction by a coordinate bench of this court in the WPC number 7878 of 2017 in the order dated 31st of May 2023. The instructions shall be made available before this court on
8 December,
10 December.
8 December.
Oblast.
Item 7.
But in this case, till date affidavit not filed, my lord.
Yeah, we have instruction. As per our instruction laws, we have the name of the petitioner could not be commercialized. Because his name did not appear in the dice data.
That is the case.
That is there.
No, that's already you file your affidavit.
Yes, we will file our-
When?
2 weeks also, we received the instruction already, so today itself.
If you receive the instruction, you file the affidavit within 1 week. Why 2 weeks?
In the meantime, also connect, SSA also has to file the affidavit here. Because dice data is maintained by the.
Who is appearing for SSA? You have received.
But I have simple ticket, my lord. John, my lord, 7 days, I think, seeking time for filing affidavit. Short date and date may be fixed, my lord. And one observation may be done without fail, my lord. That's my simple request, my lord.
Heard, Mr.
Yes.
A.K. Azad, learned counsel for the petitioner, Mr. P.N. Sharma, learned standing counsel for the respondent in Elementary Education Department. Being respondent number 1, 2,
Respondent number 1, 2, and 3, Lord.
1, 2, and 3.
Lord.
Miss Bortakur for respondent number
Number 6.
respondent number 6. Mr. Sharma and Miss Bortakur submits that they may be granted some time to file the affidavit in opposition. Mr. Sharma submits that he has already received the instruction. Then he may be granted 2 weeks time. Pair allowed races lays the matter on. In the event of failing to file the affidavit in opposition by next date, by the respondent number so and so, the court will proceed to hear and dispose of the petition without the affidavit of the respondent number so and so.
I'm
List accordingly.
Number 8. My lord, in item number 8, my lord, third, I have received from the my lord respondent. And I'm seeking, my lord, one accommodation, my lord, to file the affidavit, my lord.
Heard, Mr. A.K. Azad, learned counsel for the petitioner. Mr. Sharma for
For reduction 6, 7, and 8.
respondent number 6, 7, and 8. Ms. Fokon for respondent number 3. And Mr. Sharma for respondent number 1, 2, 4, and 5. 1, 2, 4, and 5.
Within 1 week, my lord, I will file my response.
Mr. Azad, learned counsel for the petitioner submits that he has received the affidavit filed by respondent number.
Yesterday,
7 and 8. 6, 7, and 8.
Respondent numbers. You have filed your affidavit.
yes, they are filed.
Respondent number 6, 7, and 8. And he will file his reply to the aforementioned affidavit and price for listing the matter after a week. Pair allowed, recessal is the matter after a week.
My lord, 3rd December. 5th December. My lord, Master. Items 9 and 10.
Yes, your lordship. My lord, in item number 9, petitioner. The instant case, my lord. This is my second round of litigation, my lord, and earlier present petitioner, my lord, approached before this court. My lord, in this case, if your lordship, the background of the case, like to draw your lordship kind attention, district scrutiny committee's report is very essential, my lord. I like to draw your lordship attention first that scrutiny committee's report at page 25 in my extended petition.
First you tell me what is your case.
My lord, from this scrutiny reports, then my case will go forward, my lord. Page 24.
What is your pair in this petition?
My pair is, my lord. Page 19, my lord. Quashing and setting aside the MPN Order 4/2021 issued by respondent number 2 Annexure 4, by which the service of the teachers of the Kalapani Sakatun Nisa ME Madrasa has been provincialized, excluding the service of the petitioner from provincial as in assistant teacher for social science subject. Number 2, I am projecting number 2 onwards. Directing the respondent authorities to provincialize the service of petitioner as the assistant teacher of social science subject as per the provisions of Act of 2017 and the Act of 2009. Directing the respondent authorities to implement the order dated 21/6/2024 issued by respondent number 2 Annexure 7, provincial in the service of present petitioner as an assistant teacher for the subject social science. Directing the respondent authority to consider representation dated 1/7/24 submitted by petitioner. This is my almost prayer, my lord. Yeah, my lord. Subsequently, many things development has taken place. So I am on prayer number 2, 3. 2 and 3 now, my lord. And
So where is the impugn order dated 4/2/2021?
lordship will find at page 28 annexure 4. And the table is at page 29.
Page number 20.
28 is the order and 29 is the tables of the appointee. And page 29, my lord, serial number 284 to 288, 5 page 29, serial number bottom, my lord, 284 to 288. Altogether 5 teachers named, my lord. Abu Tahir,
Serial number?
284 to 288.
Okay.
Then, my lord, scrutiny report at page 25, annexure 3, 24. This is operative person at page 25. In the scrutiny report, my lord, lordship will find
So here no teacher in the subject of social
no,
studies.
my
have
lord,
been-
my name is serial number 3. Lordship, at the very top, my lord, the tutor eligible provincialization is Abu Tahir Sheikh. At present, he is the respondent number 8 here, my lord. Abu Tahir Sheikh. Next, my lord, Sikandar Ali, he is also selected for language. My name is the serial number 3, Musarraf Hussain, from social science subject. Mehboob Alam Ahmed, he is a mathematics and science. One Qasim Ali, provincialized for language.
In page number 29, where is your name?
My name is not there, my lord.
Mm.
Therefore, my lord, I approach this code.
Mm.
All the 4 language teachers and mathematics science teachers, altogether 5 teachers selected, though the scrutiny committee recommended 6 teachers. As per the 3111/2017 next, my lord, 1 language teacher, 1 social science teacher, 1 mathematics, 200, my lord. And beyond 100 cross, then automatically, my lord, additional teachers come. Normally, my lord, here, my lord, number of students is 236, almost not. Accordingly, my lord, our school admittedly eligible teachers are 6 teachers has to be recommended, 1 headmaster and 5 other teachers, my lord. But what happened in this case, my lord? 4 language teachers provincialized, 1 mathematics. I'm not disputing for the mathematics science. 4 language teachers living inside the social science teacher. Then I approached before this honorable court, my lord. And my lord, here in the table, this scrutiny committee, lordship, very top, Abu Tahir Sheikh is the respondent number 8. Kindly marked it, my lord. And very bottom, my lord, Abdul Karim Mullah, he's the respondent number 7 here, my lord. He's the language, my lord, Hindi teacher, my lord. Then, my lord, the earlier round, when I approached before this court, this order at page 32. Page 32, my lord. From paragraph 4, I will read, my lord. The Learned Council for the petition has submitted the provision of 3111 of the 2017 Act. A minimum of 3 teachers or tutors are envisaged in the upper primary school, at least 1 teacher or tutor each for science and mathematics, B social studies, and C languages, with proviso to the effect that for additional posts shall be considered in accordance with the norms and standards stipulated right of children to the Compulsory Act of 2009. In the state context, it has been submitted that as the present enrollment of the students in the said school is around 236 students,
the service of all the 6 teachers of the said school, inclusive the petitioner and respondent number 6 to 9, ought to have been provincialized. That is the first prayer, my lord. However, the district scrutiny level had founded the following tutors to be eligible for provincialization of the service in the following spectrum. Number 1, respondent number 6, number 2, respondent 7, number 3, petitioner, number 4, respondent 8, number 5, Mehboob Alam Ahmed, and number 6 is the respondent number 9. He is the present respondent number 7 here, my lord. However, the Director of Elementary Education, respondent number 2, by the imping notification 4 to 21 provincialized the service of all the 5 tutors by leaving out the name of the petitioner. Thus, it has been submitted that the respondent number 2 had deprived the petitioner without any cogent reasons, despite the fact that the petitioner was a social science teacher. In the light of the said submission, the Learned Counsel for the private respondent 6 to 9, who are the applicants of the connected interlocutory application, has submitted it. He was otherwise prepared to make a submission to the effect that.
Okay, but what is the order passed in?
Yes,
this,
para 9. Para 9.
Mm.
Therefore, in the light of decision of this court in the hearing before, referred to Gul Nihar Begum Supra without determining the rights of the petitioner, as well as respondent number 6 and 9, this court is inclined to dispose of the writ petition by directing the Director of Elementary Education to examine the aspect as to whether the Kalapani Sakatun Nisa ME Madrasa has 236 number of students, and if yes, as to whether one additional post of teacher can be provincialized over and above the 3 teachers who were provincialized under section so. If the director arrived at his conclusion that the school is entitled to one additional post of the teacher, he would further examine as to which is teacher of the school is to be provincialized against the additional post, and in doing so, the case of the petitioner shall also be given a due consideration. The requirement of the director will examine and pass a reason order to be done within period so. Thereafter, after passing of this order, my lord, very next page 37, annexure 6, my lord.
Mm.
On 18th of July 2023, my lord.
Mm.
In compliance of the Honorable High Court's order dated 16/3/2022, also based on report hearing dated 29/5/23 in respect of so Mosharraf Hussain so. In respect Abdul Karim Mullah, this is respondent number 7 here, my lord.
Mm.
Because of the Kalapani Sakatun Nisa ME Madrasa Gauripur Education Block of Dhubri district hereby cancelled. Accordingly, my lord, respondent number services has been cancelled by this order, my lord. Consider
Respondent number 7.
7 here, my lord.
Mm.
Abdul Karim Mullah. Then, my lord.
Who is the writ petitioner in the next case, item 10?
Yes, my lord.
Mm.
Yes. Then, my lord, very next page, sorry, page 40, annexure 7. It is the order passed by the Director of Elementary Education on 21st June 2024. This is very important order. I like to read this order, my lord. Whereas the Honorable High Court passed an order dated 24/4/2024 in WPC number so, arising of WPC number 2140, the instant petition, my lord.
Why this order was passed?
This order passed 2024, considering, my lord, to earlier order of education, that order, my lord.
Mm.
Just I read that order, my lord. They have
By that order, they have cancelled
his
one of the.
cancel. After cancellation, my lord, this order passed, my lord.
So provincializing your service.
My lord, they recommended, my lord, 6 teachers here again, my lord. After cancellation of the respondent number 7,
Mm.
4 teachers. 6 teachers named, my lord.
Mm.
The Honorable Court passed an order to the WPC with direction to the Director of Elementary Education Assam to examine the aspect as to whether the Kalapani Sakatun Nisa ME Madrasa has 236 number of students. Yes, as to whether one additional post of the teachers can be censored. If the director arrived at his conclusion that the school is entitled to one additional post of the teacher, he would further examine as to which teacher of the school is to be provincial against the additional post of doing so. The case of the petition shall also be given a due consideration. Now, my lord.
Mm.
Whereas the District Elementary Education Officer Dhubri submitted a proposal with recommendation of DSC Dhubri for provincial service of 2017. Kalapani Sakatun Nisa Madrasa ME, number 1, my lord. Altogether, the 6 recommended, these are named, my lord.
Mm.
My name is, lordship kindly have it, number 3, my lord.
Mm.
Mosharraf Hussain in social science subject, my lord.
Mm.
Now, my lord, skip to my lord. Bottom, my lord, whereas as per 3111, from that onwards I'll read, my lord.
Mm.
Whereas as per the 3111/2017, the Kalapani Sakatun Nisa ME Madrasa, now ME school, was entitled for provincial service of 5 numbers of teachers based on the enrollment position of 170 during 1718. Whereas the dice relating information as received from the SSA, Assam was placed before the SLLC as well as the joint committee. After due verification, both the committee recommended the following 5 numbers of teachers for provincialization. The tutor against the Kalapani Saint Joseph Madrasa. Thereafter, this office submitted proposal to the GOVT for creation of post for tutor in respect of the above mentioned teachers against Saint Joseph Madrasa. And upon receipt of the court sanction of the post of tutor, this office issued provincialization services order following tutors. My name is serial number 3, the Mosarraf Hussain Lordship. In view of the above, the Kalapani Sakatunnisa Madras is not entitled for provincialization of more than 5 teachers under 2017 based on enrollment for the year 16-17-17. This is the issued compliance of this honorable court direction. This is the order pass. They out of 6 milord, this school entitled 5 numbers of tutors. Now, milord, in the meantime, milord, the present petitioner, milord, not consideration his prayer, milord, he approached before the file a contempt petition. During contempt petition, the order I have read 21st June 2024. It is placed accordingly. My contempt case was closed. Now, milord, the respondent number 7 here, milord. Respondent number 7, when his post was cancelled on 18th of July 2023, the annexer 6, milord, he challenged a writ petition before this court, the annex item number 10 here, milord. He got in very first day, got interim order state that his cancellation order, milord. That is at page 48, milord.
Hmm.
48. Oh, is it? My lord, here, my lord, the respondent number 7 obtained this interim order on 2023, but my lord, in the 2024, that is the 21st June 24, his name is also included, my lord. His name is also included there, that 21st June 2024 order.
20?
In annexer 7, my lord.
Yes.
Respondent number 7 name has also been recorded here, my lord. Abdul Karim Mullah, my lord. Then, my lord, in the meantime, my lord, 2 orders I have enclosed in my writ petition. I will come later. Now, my lord, what is the stand of the government here, my lord? Affidavit in opposition filed by the respondent number 2, my lord. Opposition filed on 17/7/2025 by the respondent number 2, my lord. And that is page 67.
No, if your name is approved and also the name of the respondent number 7.
Yes, 6 teachers.
Petitioner in WPC number 4628 of 2023 has also been approved. Then what is your grievance?
No, my lord, now question is, their stand is, our school is entitled 5 teachers. As per their stand, my lord. And who is 5? This is the question. Then this honorable court squared for the eligible teacher for provincial of this school, my lord. Then, my lord, they filed 2 application, the final affidavit, my lord. I like to draw your lordship attention, my lord, at page 85, my lord. That is the latest affidavit file on behalf of the respondent number 2. Here, my lord, paragraph 3. Page 86, my lord. Page 86, para 3, my lord. With regard to the statements made in the writ petition, the answering deponent respectfully begs to state that this honorable court, by order dated 22/7/25, is directed to produce the list of teachers who are eligible to be provincialized and 5 posts as per the provincialization of service 2017, my lord. Done, my lord. Page 89, my lord. The last The bottom paragraph onwards, I'll read, my lord.
Hmm.
That a meeting of the state level scrutiny committee was convened on 12 2022 with regard to the court cases filed in respect of provincial and service of egg under 2017 under the chairmanship of the answering deponent. Accordingly, an inquiry has been conducted to verify the documents of 10 RLP under the Dhuburi district as per report submitted by DO Dhuburi with recommendation of the district scrutiny committee for provincialization under 2017 Act. Upon verification, in respect of the school discrepancies have been found in the recommendation of the teachers, as the name of the teachers recommended are different in hard copy in prescribed format and the copies of the prescribed format sent through email. Further, more than one language teachers was provincialized in violation of the section 3111 of the 2017. And accordingly, in view of the above, committee examining the stated facts and in pursuance of the DICE verification report SSA, Assam, as the name of the petitioner found placed in DICE data for the year 2011-12 and afterwards as per minutes of 24/7/2020 of the joint committee constituted by the GovTov state level scrutiny committee decided to recommend the name of the present petitioner as social science tutor and teacher and tutor against Kalapani Sakatunisa ME Madrasa ME School to the GovTov provincialization service as per the 2017 by cancelling the service of one of the language teachers, junior most language teachers, and the minutes of the state level, they have enclosed. I will take your lordship and scrutiny committee report. The answering deponent humbly begs to state that the respondent number 7, herein named Abdul Karim Mullah, whose service was initially provincial as a tutor, along with 4 other teachers, Kalapani Sakatunisa ME School, as well the wide notification dated 4/2/21, which is also under challenge in the present date petition. Approach this honorable court on WPC number so-and-so, challenging the order 18/7/23 passed by the answering deponent, whereby the provincialization order dated so-and-so in favor of the respondent 7 Abdul Karim Mullah has been cancelled. This honorable court wide order dated 11/8/23 passing WPC so-and-so filed by Abdul Karim Mullah, this is item number 10, my lord. Herein, while issuing notice in the interim, suspended the order dated 18 July 23 passed by the answering deponent has been stayed until returnable date. In view of the above, and as per the recommendation of the DSC Dhuburi, following teachers are eligible for provincialization of service as tutored under provision of 2017 against Kalapani Emima School. Number 1, Abu Tahir Sheikh, this is the respondent number 8, my lord. And my name is serial number 5, Mosaruf Hussain, social science, my lord. And respondent 7 name is not here. As per this report, he is not eligible for the provincialization. It is as per the latest report of the government, my lord. I'll take it. Scrutiny, my lord.
So now you perhaps no grievance in this
I'll
petition
come, lord.
to be elevated.
My lord, this case will end. I wish, my lord, that my school admittedly, my lord, 1 headmaster and 5 is admittedly as per the law, my lord, right to a film compulsory, my lord, education and
Okay,
RT Act, my lord.
okay, Mr. Fukan, this affidavit is common in both the petition.
After that, I'll just indicate my stand, department stand in this case.
Yes.
Regarding this.
So now what left to be decided? No,
I will go by the NUPA diets, because that is going to play a crucial role.
no, that's all right.
In particular.
No, now you tell me, is there anything to be decided in this petition? Because you have already taken a decision to provincialize his service.
So my lord, people whom.
So now we have to decide the other petition only.
As per the NUPA diet, so we follow the NUPA diets. The NUPA diet, whoever is eligible as per the NUPA diets, my lord, maintained by the, my lord, that particular thing, we will provisionize those people. There was a confusion previously, my lord, therefore that was cancelled. And my lord, after proper scrutiny and after proper, because as taking and correlating with NUPA diets, the NDA again, I affidavit, my lord, saying that these people are the 5 people is not should see to be director. In paragraph 3 above paragraph 4.
No, my question is there anything to be decided in this petition? Because you have already taken a decision to provincialize his service.
In view of the above, recommendation of DSC, the following teacher are eligible for potential of teacher under provisional instructions as currently. Means to issue school, Sala, so my lord. P111 says my lord there has to be a language teacher, one language teacher, one science and mathematics and one.
No, no, you are not following what.
My lord,
বেলেগ সুধিছে। Since the respondent authorities have taken a decision to provincialize the service of the petitioner, is there anything to be decided in this petition now?
that is the only thing that he will.
So now we will adjudicate only the writ petition number 4628 of 2023. Second one.
Take only 5 seconds. What my friend has said in annexure 7. Annexure 7, that is page 40. Then in that annexure 7, all three of us are there. All the 3 persons are there. That is Abu Taher Sheikh is he, me, Abdul Karim Mullah, and my friend is Musharraf.
Then that's all right. Now he has abandoned his prayer
No,
by
what-
which he challenged that order.
Yes, what I'm saying.
Now he is only for provincialization of his service.
Yes, my lord.
The pair number 2 and 3.
Yes, my lord.
And the state respondent has taken a decision to provincialize his service. So his grievance has been addressed in this petition. So now we will independently deal with your pair in the other petition.
Yes.
What I'm saying, annexure 7, page 40 goes to show that they have, though the recommendation was in respect of both, that is in the year 2024, my case is of 2023. What I'm saying, this order is issued after my case. Over here, name of all the 5 persons are there. Do they want to change that? If my lord looks at page 41, I'll take only 3-4 seconds.
Page number 41.
Page 40.
Yes.
My lord, this is dated 21 June 2024. My lord, what? That is after my
Cancellation.
cancellation and after my stay or after filing of my repetition. That is item 10. What they are saying in 2024, on 21st June, that the DSC has given the 6 names, they have done these 5, they cannot add another. If this is the 5 names are there, then he is covered, I am covered, and my friend respondent number 8 is covered. Do they want to say anything more than this?
Yes, sir. Regarding this, my lord, what the page 40, annexure 7 is showing, that is regarding the previous email. After that, now we have filed an affidavit. Bringing on record, we have tallied it with the TIAS data maintained by the NUPA with the assets email. There we have seen that, my lord, we have ultimately stated that, my lord, Abdul Karim Mullah is the language teacher. But already having language teacher. And he has been entertained, my lord, because previously his name was cancelled because of the fact that he's a social science teacher. So since there has to be a language teacher, there has to be a science and mathematics teacher, and there has to be a social science teacher as per the group P111. Based on the pupil teacher ratio, we have the academic which we have filed. We have said that based on the year-wise chronology manner, 5 teachers manner. In that manner, again will come to the academic again.
Okay, Mr. Pocono will resume after 5 minutes.
Yes.
Yes, my lord.
Mr. Bedin,
Yes, my lord.
have you filed your reply to the affidavit in
Yes.
opposition filed by the respondent, state respondent?
Yes, yes.
But yes, I find.
You have filed? Okay.
My lord, would you lordship be pleased to take item 10? I'll take a very short time, then we can go to the item 9, which is 2024 matter, mine is 2023 matter. It does with the sequence. I will not break the sequence. Or your lordship may continue with the 24 item 9 as your lordship wishes, my lord.
Okay, let us first finish item number 9.
Okay.
So your affidavit in this item number 9,
Item number 10, my lord,
your
in my
reply
case-
affidavit.
In my case, nobody has filed any affidavit.
It was taken up together, madam. So we had signed it because the same.
Okay.
So it's not a provincial entity.
Okay.
No, but one thing, my lord, before your worship proceeds, further, my lord, I would like to say that there is a affidavit in item 10 is also must.
Hmm.
Why? In pursuance to the order, my provincialization has been cancelled.
Hmm.
This is the case, and I got a stay. How did they cancel? That everything was questioned in this petition, but that is not answered. And if they say, no, it's not required, item 9, affidavit will cover, I have no objection, madam. Only thing that after hearing for another 2 hours, suppose the requirement of affidavit is needed, the unnecessary, madam, 2 hours will be given. And if we are going for a final today admission hearing, my lord, well and good, no problem. I have no issue, my lord. Because if my petition remains, my pleading remains uncontroverted, it's beneficial for me.
Hmm. Mr. Fukon, your affidavit is in page number?
85 minutes.
Page 85.
That is good. 85.
85 minutes. Facts at 85, and at 101. Well, the relevant portion is lordship sees. So lordship will get the sequence over here, man, and read it out, man. Initially,
No, Mr. Fukon, you say in this affidavit,
my lord,
where you have mentioned the number of the other writ petition. And where is the averment that this affidavit is in connection with both the matters?
lordship, what happened was the petition was tagged with this matter.
Tagged with that order, all right, but you ought to have mentioned the number of the writ petition in this affidavit.
Why not we filed it in this one, because this was subsequent. This was 2024,
Hmm.
that was 2023. So because subsequently this was filed, this was the main case which everybody was arguing on. Today, my lord, he has brought up the topic, my lord, that and my lord, in the my lord, in the today the topic has been brought out regarding his my lord feeling that we should file an affidavit against us also. But in all these days, my lord, before this matter has come up in before many courts, this meeting was not taken. And my lord,
My friend is saying
and
that
my
I
lord,
can
and
this,
my lord,
I withdraw that what I have said.
my lord, and one more thing, my lord, if lordship comes to, there is a mention about, my lord, 4628 of 23 at page 91. There is mention, my lord. of, my lord. It is there, my lord. Sometimes it's not mentioned, it is connected. Yes, no, 91.
19 last line. 9091.
Whereas after this, my lord, after this, we have gone through the report as, my lord, which is maintained by the SSA, my lord, which is available records, my lord, of the National University of Education Planning and Administration, New Delhi. This is the main record, my lord, which we have to always follow regarding this.
Where is that record?
My lord, that report, my lord, based on that report, we have got the instructions to file this affidavit. So we have filed this affidavit,
No, whether that report is part of the record.
yes. My lord, it is there, my lord.
Where?
It's the 93, my lord.
Page number
93, my lord.
93.
It's one of the parts, my lord. The whole thing is not there, my lord. The whole thing is not there. Based on this, my lord, the paravise has been made on the director, because we checked the paravise. Based on this, my lord, we have given that they have said that, my lord, the 5 people are to be recommended, my lord, not 6, my lord. And among them, my lord, these are the people, my lord. In view of the above, as per recommendation of the GSC, Dhubri, the following teachers are eligible for provincialization as teachers under the provisions of the Act of 17 against Tala Patani, Pakatun, Nessa, and Istu.
No, no, where is the DIS data?
That will be, otherwise it will be with the SSA. SSA also is a party. But
No,
what
no,
is the detailed
SSA is a
party?
party, that's all right, but your affidavit is based on
By
the.
the paramount sent by the director. It's
Hmm.
with them because they have received from them only.
But
Based
why
on the paramount-
why the data is not part of the record, part of your affidavit? Hmm? And based upon the said data, you have cancelled the provincialization of service of the respondent number 7.
Yes.
And that data is not available before the court.
That one the SSA will be able to provide because SS is the.
No, SSA,
Custodian of the, kindly sees, kindly have the book.
Hmm.
Page 103 of the book file. The DIS code base.
Hmm.
The DIS data is maintained by the SSA. It's prepared also. We have to go by that. That's for book by, that's for rules. DIS
no,
means
you
DIS
have called for the data and you have received it.
No, we not called for the data, but we have received from the SSA the
Yes,
concerned data.
that data you have received from the SSA, you produce it before the court.
It might be required, they must have sent it back also, we don't know, that's required, that's required. But the second, the first case. they have not sent it back.
How can you send the data back to the SSA?
Keep sending, whenever we are required, for example, this case is there,
Hmm.
they send the report file, so then my report might be there, but this thing might not, we have to ask the SSA also. Whenever we'll take it out, we'll call the SSA council also. The second case, the second case, the SSA is a party.
Hmm. Okay, you call him. Okay, after some time.
My friend is talking about the fetus when the baby is already going to the college.
Pardon?
My friend is talking about a fetus, but the baby is already grown up for the college.
Hmm.
This, when the DLC takes up the matter, unless and until 2009 and 10 DIS is fulfilled, the person's name is not recommended.
Hmm.
Everything is over, even the provincialization is not over. What my friend is saying, this is the second affidavit. Now the question will arise. Why there is a second affidavit? And my lord will put that question, I know it.
Hmm.
Because everything is same. Only there is a change of one paragraph, about 5 lines.
Hmm.
That was the requirement of
No,
filing the
okay,
second affidavit.
let the council of the SSA come.
Number 11.
No, here, my lord, the case, my lord, the last one, my lord, I think on 10/9/2025, state break for time, 2 weeks, my lord, 10 September. And 4/8/2025, just now, 3 and 4 took time, my lord. Here only cases related to my lord. This, I have given promotion, my lord. So annexer R 64, my lord. But they have not filed affidavit till late, my lord. This I have give promotion by this by notification, my lord. This it was notified to 19/2022, my lord. I'm a assistant professor, my lord. So it was, my lord, page 65, my lord.
Mr. Bhakhtir for respondent number?
I thought as well 3 and 4 instructions are given, some both are maybe running, so they will consider instruction and find out.
Go for respondent number 3 and 4.
My lord, this the government advocate told me, my lord, this there's a letter, my lord. I have shown, my lord. The only college authority has not submit the proposal to the men, my lord. My
In
friend is
respect of
So that means they are not much as long.
who?
For the higher university.
Who?
S
does.
Yes, does.
Already called him.
Yes, someone.
Okay, after some time, let Mr. Das come.
May please your lordship, ask for timing lordship, say for pass of timing lordship.
I think kindly please the matters on other day then.
Why?
I have some difficulties. And when I have filed my affidavit, lordship, they have filed to reply, ready for disposal.
They have filed their reply. You have received.
After Sunday, my lord.
After.
But if she has some difficulties, then
Is coming, yes. I can wait.
after some time. Okay, okay.
One instruction from how to. Is that regarding fixation of pay in the selection and the schedule. The process is going on and for the proposal for placement in the associate scale of pay has not been submitted by the college authority. Sometimes
So that is only in respect of selection grade.
Yes.
But in respect of promotion to the post of associate professor,
Yes, madam. This college authority has to take decision. madam.
you are for college authority.
Yes, please.
Why the proposal has not been sent? Okay.
My lord, short date may be given. My lord, this
Okay.
case is filed on
Heard Mr. Mehdi,
February.
learned counsel for the petitioner. Mr. S.K. Das, learned standing counsel for the respondent in higher education department. Mr. Bakhtiar for respondent number 3 and 4. 3 and 4. Mr. Bakhtiar submits that he may be granted some time to obtain instruction and to file the affidavit in opposition. Fair is allowed. Mr. Das has also produced one letter dated 9th of September 2025, issued by the Deputy Director of Higher Education, addressed to the Standing Council, Senior Standing Council, Guwahati High Court, informing him that the file regarding fixation of pay in the selection grade of pay in respect of the petitioner is currently under process at the Directorate. And on the basis of the said letter, Mr. Das submits that he may be granted some time to obtain up-to-date instruction. We are allowed recess and list the matter after.
My lord, on 9th of December, because my lord, he is entitled, my lord, eligible for 2007 itself, my lord. And my lord, my friend, my lord, took time, August, my lord, my college authority, my lord. College authority, 4/8, my lord, August, my lord. Now it is, my lord, November, my lord, 19, my lord. So short date may be given, my lord. Otherwise, my lord, they will not file, my lord. 9 December.
9 December.
Yes.
In the event of failing to file the affidavit in opposition by the respondent number 3 and 4, the court will proceed to hear and dispose of the petition without the affidavit of the respondent number 3 and 4.
Item 13.
My lord, here in this case, my lord, yesterday, my lord, when I full file, my lord, APT reply, my lord, APT in opposition, my lord. Yesterday, my lord. It is not in record, my lord. Here, this case is, my lord, regarding, my lord, I am the senior most, my lord, I am working as an assistant headmaster, my lord. But charge was given to junior to me, my lord. He is only teacher, my lord, assistant teacher. I am cadre post, my lord. The headmaster post is vacant, my lord. So in charge should have been given to me, my lord. But it was given to the junior, my lord. Yesterday, they filed an affidavit, voluminous page 91 page, my lord. That part, so far junior seniority is there, my lord. Only this allegation, some allegation newly, it was after that, my lord, they prepared, my lord. So I required to file, I'll file a reply, rejoinder, my lord. So I will be allowed, my lord. It is also not in record, my lord. This, they are in opposition, my lord.
Withdraw, please. Withdraw.
Yes.
Lordship, it has been withdrawn. The academic in charge, the order by which the respondent was made the in charge, academic in charge. That order we have withdrawn it, Your Lordship.
But who is in charge of the headmaster now?
Schools, Your Lordship.
Pardon?
Inspector of schools. He's in
Inspector of
charge,
school.
Lordship, the school. He is a principal in charge, Your Lordship.
If it is withdrawn, my lord, then the matter is in practice, my lord.
You see the, first you see the order.
Yes, madam.
Madam, you furnish a copy to him.
Yes, madam. And then madam, we come on 9th, I'll, madam, take.
Instruction.
Yes, madam.
Heard Mr. S.K. Maini, learned counsel for the petitioner. Ms. Musari, learned standing counsel for the respondent in secondary education department. And Mr. H. L. Laskar, learned counsel for the respondent number. Private respondent. During the course of deliberation, Ms. Musari has produced one order dated 18/11/2025, and on the basis of the said order, Ms. Musari submits that the order dated 22nd of May 2025, by which the private respondent was given the academic inserts, given the charge of academic inserts of the school, has been withdrawn. At this stage, Mr. Medhi, learned counsel for the.
Not need, madam, it's already withdrawn, madam. So one observation is required, madam. I pray, madam. When they give next some it was given to somebody, my lord. It is, my lord. Then the seniority may be, my lord, followed, my lord. Observation, my lord.
Then seniority.
My lord, when next time the academic in charge of the school is suppose there is the order passed by the IS, my lord.
No, we are not closing the petition, or we will close the same.
Yeah, close. Yes, my lord. If your lordship may close this because the already that order is withdrawn, my lord.
Okay.
Only of that observation may.
কি বলো তোমার লাইন? At this stage, Mr. Musari submits, Mr. Medhi, learned counsel for the petitioner, submits that since the order dated 22nd of May 2025 has been withdrawn by the respondent authorities, this matter become infructuous. However, he submits that an observation may be made to the effect that whenever the appointment of in-charge headmaster is considered, then the seniority may be considered.
My lord, there is judgment, my lord. I'll show, my lord. If there is judgment, my lord, I'll show the judgment, my lord. There is judgment, my lord. My lord, why? My lord, no, so far, my lord, this judgment is, my lord, this judgment is there, my lord. This judgment says even, my lord, in charge, my lord, seniority must be, my lord. This is the judgment.
However, the learned counsel for the private respondent has opposed to the submission being advanced by Mr. Medhi, but taking note of the submission of learned counsel for both the parties and also the decision referred by Mr. Medhi, learned counsel for the petitioner in Pradeep Chakraborty versus State of Assam, reported in 2012 legal GAU 764. This court is inclined to dispose of this petition being infructuous. However, it is provided that whenever the question of appointing in-charge headmaster arises, then the respondent authorities shall consider the same in accordance with law. Not necessarily in accordance with law. If that is the law, your submission is the law, then they will follow it. Mr. Chaudhary,
That's fine.
you are for SSA.
Item number 9, I'm making.
Item number 9 or 10?
Yes.
9 or 10?
9 on the.
10 or 2 as suppose. Kira, mo 9 or 10. Dapat side option. Second party of another thing.
No.
Oh, side.
In 10 laws, I have not been impeded.
Okay. You are in 9.
10 million, 15 not. Not implemented, SSA. In my attempt, I have implemented. Move close to this.
So, Mr. Sodhuri,
Yeah.
the state respondent have filed their affidavit in opposition. And in the said affidavit in opposition, they have relied upon the data furnished by the SSA. So, paragraph number 3, page number 87. The joint committee decided to verify the following parameters of DIAS data maintained by NOPA. So page number 88, in the first paragraph, the SSA Assam submitted the DIAS data verification report maintained by NOPA. And based on the DIAS data verification report furnished by SSA, they have taken a decision to provincialize the service of 5 teachers. But knowingly or unknowingly, the state respondents have not enclosed the said data as part of this affidavit. Mr. Fukon is not sure as to availability of that report in the with the respondent authorities. Therefore, he called it.
Lordship, going by the improved order, page 40 and as well as the relevant paragraphs, it appears that the same report was submitted before the joint committee as well as before the state level scrutiny committee. Lordship, it must be with they must be maintaining the record, Lordship. It must be with along with the other documents which were taken into consideration for provincialization. I can give the chart, Lordship. I have that. Lordship, this is
Now, any one of you have to produce the report before this court on next date.
We have report dated and also both of us can give letters.
Lordship, his record will be more relevant because the other factors and documents will be there. I can give only the report forwarded by the SSA.
No, only that report is necessary. So, by next Friday, not coming Friday, in the next Friday.
Next Tuesday or Thursday. So is there a question where you can question?
No, that's all right. But provided they make available the record before this court.
Lordship, 27.
What my lord has just pointed out once in a stage paragraph 3 of this affidavit. So the requirement of the tax data, what are the requirements? Those answers are also given in the subsequent paragraphs in subparas in paragraph 3. And possibly, my lord, there is no argument on the dice data value. It is not the case that my name is not there in the dice data. The answer is there. You also looks at the page. What my lord has pointed out, the paragraph 3. The paragraph 3, my lord, page 87 is the relevant partner. Based on the recommendation of the district services of the ultimately they have verified the LUPA and they have come to 3 things, my lord, whether the name of the school appears in the dice data.
No, Mr. Abedin, you say, based on the report of NOPA and furnished by the SSA, they have cancelled your provincialization. No, you see this criteria laid down in the act.
That is the
Last part.
I mean this great that whether my name has been because of the LUPA. No.
No, they have verified it.
For that, but it's not because of the LUPA, because I did not have the dice data, because my name is my name is there in the dice data, it is seen in the district recommendation report.
No, you see, paragraph number 80, no, page number 88,
Yes, madam.
the third paragraph.
Yes, madam.
Accordingly, the dias related information.
Yes, my name is there. My name is mine. These are the person who give it. Thank you.
Yes.
On the second paragraph, we are not to be discussing. That accordingly, it is one paragraph, where you did not. That accordingly, in view of the above, the committee assumes the stated facts and questions of the dice information variable so and so as the name of the account in place so and so 2019, 2011-12, and afterwards, as per my note so and so of the joint committee or subcommittee so and so decided to recommend the name of the petitioner as social science teacher, tutor against Kalapani Snagato so and so to the government of provincial by cancelling the service of one of the language teacher rated junior most amongst the language teachers. That was the decision. I am the senior most founder teacher. That was the case before my lord in item 10. What your decision is to remove.
No, but Mr. Fukon submits that on the basis of the report of the SSA, the provincialization of service of respondent number 7 has been cancelled.
Our next question is beyond the pleading. But anyway, I leave it to your motion, let them produce the thing. We get the report.
No, is it necessary then if it is not in your pleading?
The report come and.
My friend will help me.
On proper education.
This is proper education, yes. I agree with him.
Heard Mr. Deca, learned counsel for the petitioner in item number 9. And Mr. Abedin in the petitioner for respondent number in WBC number 4628 of 2023 in item number 10. Mr. Chaudhuri, learned standing counsel for SSA. Mr. Fukon for the respondent in elementary education department. And Mr. Abedin for respondent number 7. And Mr. Das
For respondent number 8.
respondent number 8. Heard in part. Place the matter on. When?
Next week.
Tuesday. Tuesday,
Yes, Milord.
4th of December, 4th of December. In the meantime, Mr. Fokon and Mr. Sodore, Learned Standing Council for the respondent in Elementary Education Department and SSA shall produce the DIAS data.
Of 2009 and 10. The cutoff is 2000.
DIAS data and the report furnished by the SSA before the joint committee and the state level committee on that day.
Our petition. Obliged.
Interim order passed in, item number 10 shall continue.
Item 12. May I please, Your Lordship. Lordship, this matter is, Lordship, basically for challenging the recovery of excess dwell, Lordship. Lordship, the fact is that, Lordship, after retirement, Lordship, my pension papers were submitted before the Accountant General, Lordship, and the Accountant General observed, Lordship, that there are some excess dwell, Lordship, due to wrong fixation. In this, Lordship, from 1/4/2016 to 31/8/2023, and accordingly returned my pension papers to the department, Lordship. And then, Lordship, department, Lordship, prepared the recovery statement and resubmitted my pension papers before the Accountant General. And then, Lordship, the Accountant General, Lordship, my finalized my pension, Lordship, and direction was issued to recover the said amount, Lordship, to the Treasury officers. And the Treasury officer has recovered that amount from my pensionary benefits, from DCRG and amount of monthly pension, Lordship. And in this case, Lordship, my the Department of the Transport Department have filed their affidavit, Lordship. They have two stand, Lordship. One stand is that, Lordship, being, Lordship, enforcement inspector, I am in second class service, Lordship, and my case is not covered by the Rafiq Maji. And the second one is that, Lordship, I was the in charge of that department, Lordship, and I am aware of that anomalies, Lordship. And to that effect, Lordship, I have filed one reply affidavit, Lordship. And, Lordship, with regard to, Lordship, any class, entitlement of benefit of Rafiq Maji, Lordship, this honorable court passed an order, Lordship, in Saran Kumar case, Lordship. Saran Kumar case, very latest judgment, Lordship. Here, this honorable court, Lordship, held that, Lordship, in any way, after retirement, Lordship, recovery is not permissible, Lordship. And with regard to my service as in charge, Lordship, I have clarified my stand, Lordship.
So you have retired in the year?
I got retirement, Lordship, on 30 August 2023, Lordship. Wrong fixation with effect from 1/4/2016.
Wrong fixation relates to the year 2016.
1/4/2006 with effect from 1/4/2016 till the date of my retirement, Lordship.
So what was your position at that point of time?
Lordship, enforcement inspector, Lordship.
Who is the drawing and disbursing officer of
DTO, Lordship, district
DTO.
enforcement officer, Lordship.
DTO?
And there is one allegation in, Lordship, the affidavit in opposition that I was DTO, Lordship, in charge DTO. I have clarified that I was in charge. Yes, in charge DTO for only 2 months, Lordship. That is with effect from 18/7/2019 to 29/10/2019, Lordship.
Inserts from
Incharge DTO, Lordship. I
with effect from
incharge DTO.
with effect from
18/7/2019 to 29/10/2019, Lordship. On 1/11, Lordship, regular permanent DTO joined, Lordship, in the office.
no, you have you are not in a gazetted position.
Not in the position.
Okay.
This is Saran Kumar case, Lordship, the case was filed by one Inspector General of SSB, Lordship. And in this case, it was held that, Lordship, after retirement, Lordship, it is not permissible, Lordship. If Lordship, may-
Okay.
No. No. Follow up.
So the amount has already been recovered.
Recovered, Lordship. Lordship. Page, Lordship.
What was the amount?
Lordship, amount is, Lordship, 21, Lordship.
14,71,300.
14,71,394.
394, my lord.
So what is your stand?
Yes, lordship, first of all, my lord, is a grade 2 officer. And lordship, graphic marks is not applicable here, and Saran Kumar is also not applicable in this matter. Why, lordship? Because as a DPO in charge of this particular district, he was the custodian of these all documents. Lordship, may kindly have a look my affidavit. That's page 75, paragraph 6 and 8, my lord.
Yes.
May I read, my lord? Paragraph 6, there is record the statement made in paragraph number petition that the opponent makes to state that the petitioner was well aware about the access grant from 1/4/2016 to 31/8/2023. The deponent further begs to state that the petitioner was discharging his duty as the in-charge district transport officer from 18/7/2019 to 29/10/2019, and again he was the DPO Hojai from 14/11/2022 in his superannuation from service. The deponent begged to state that
No, madam, you say the period relates to 1/4/2016 to 31/8/2023.
in his retirement. Lord.
Yes, but he was inserts DTO with effect from 18/7/2019 to 29/10/2019.
Yes, Lord. Again, he was
So-
the in-charge DPO till his retirement.
No.
From 18/7/2019 to 14/11, Lordship, I am coming. What I am saying so in our affidavit, Lordship, may kindly. The deponent begged to state that the petitioner was the overall in charge of the office and he himself was the custodian of the service book and other relevant documents and had clear knowledge about the access grant of an amount of rupees 14 lakh.
No, madam, you see the access drawal starts from 1/4/2016. At that point of time, he was not the insurance DTO.
The Lordship, page 44 and 46 of the repetition manner that we have stated in the later part. The deponent further state that annexure A of the repetition, page 41 to 43, clearly shows that the present petitioner has full knowledge about the access to it.
Who is,
Page 40,
who-
the repetition manner. This is the
no, in your affidavit, in which paragraph you have made such averment?
Page 6, Lordship. That the third, below third line of the page, paragraph 6 manner.
Yes.
Lordship, annex the page 44. This is the signature of the petitioner. He was well aware of what is happening in the service book. And he was the custodian of the service book. No one else. Page 44 is his signature. 44 to 46, it is the signature of the petitioner. And second point, Lordship, is noted page 44.
Mm.
This is the signature of the petition and the district transport officer, my lord. Then Lordship, paragraph 8. Because he is the grade 2 officer, he is not a grade 3, grade 4 officer, my lord. Paragraph 8, Lordship may kindly have this.
Paragraph?
8, my lord.
Mm.
I'm relying only 6 and 8, Lordship.
Mm.
Paragraph 8, my lord.
Mm.
May I read, my lord?
Mm.
In record the statement in presence of 1200 petition, the deponent denied the same and humbly submitted the post of enforcement inspector falls under the class 2 as per government notification number. A copy of the annex is page 78 Lordship may guide the type of page 78. Here reading is that he is not a grade 2 officer. It's as per notification and as per the rule, he is a graduate officer, my lord. Relevant portion Lordship will find page 79. Class 2, my lord. Class and cadre, 3C. Page 79, Lordship.
Then whether payslip was issued to him? Because gazetted officers are usually issued with the payslip.
That will definitely provide to the petitioner because the Lordship enforcement inspector, then the second page 80. 3, Lordship, point number 3, the status of member of the service included in the cadre of classes 1, grade 1 and class 1, grade 2 shall have transfer gazetted government service and those included in class 2 shall have class 2 gazetted government service.
Mm.
So enforcement inspector is a gazetted officer, madam.
Yes, Mr. Talukdar, did you issue payslip to him? Yes.
Department has followed with the past, Professor Lordship.
No. Since he was a gazetted officer, whether payslip was issued to him? Yes. No, that is my question. Whether you have issued.
Whether it was issued or not, Lordship, and normally gazetted officer tested, Lordship, accompanies the letter authority.
Yes. Mr. Talukdar, whether payslip was issued to you by the AG?
Lordship, I am to take instruction, Lordship.
You are
Probably
taking-
not, Lordship.
Merely because of the petitioner was a gazetted officer, he is not entitled to the benefit on the basis of the decision of Supreme Court in the case of Rafiq Masses. Hmm.
As class of officials, Rafiq Masses included, my lord, specifically mentioned. Okay, I had emailed her.
In Saran Kumar case, Lordship, everything is explained, Lordship, and Saran Kumar case.
So, kindly have a look, Rafiq Masses for a moment. paragraph 18, my lord.
Does reset? Okay, not necessary. Okay, all right.
Where did, my lord?
Yes, paragraph number 4 of the Rafiq Masih's decision.
18, the recovery from the employees belonging to class 3 and 4 only included.
He is not covered by
not
one.
covered.
Yes, number 2. Number 2. Point number 2.
Recovery from the retired employees.
Hmm.
Or the employees who are due to retire in 1 year from the order of recovery. But this Rafiq Masih is only for the grade 3 and grade 4, not for grade
Is
2.
it? Are you sure?
Yes, my lord, this is the rules, my lord.
Hmm?
But if I will provide some more judgment, I will also research. Gandhi, 1 day or 2 days time, I will also look. Sir, Rafiq Masih is not applicable in this matter. Only grade 3 and grade 4.
Is it?
Yes, my lord.
Hmm. Okay. Developer data decision of access. Developer data.
Another thing was that he was the custodian of his own service books and his signature was there, my lord. So it is the public money after lordship, we cannot allow anyone to take access what he deserves.
No, that's all right. The fixation was made in the year 2016.
Yes,
At
sir.
that point of time, he was not the drawing and disbursing officer.
That's true. But after that, for fraction of period,
But
he was the in
the
charge of the service book.
anomalies started since the year 2016.
Listen, that's right, my lord, but he was well aware what he was doing, what he could deserve. Not give any officers to draw excess amount, it's also public money, my lord. But he's a great together.
You also go through one of the decision. 2016-14 SSC 267. And thereafter you apprise this court whether in respect of gazetted officers, the ratio laid down in the case of Rafiq Masih will be applicable or not.
Lordship, I'll go for my lord. My lord.
Heard Mr. Talukdar, learned counsel for the petitioner. Ms. M.D. Bora, learned standing counsel for the transport department. Mr. Talukdar for respondent number 4. Mr. Soliha, you are here? Respondent number 2 and 5. 2 and 5. Heard in part. List the matter. Okay. December.
9 December.
9th of
Lord,
December.
Before 8 December, my lord. From 8 to 12, and then before 8, before 4.
4th of December. In the meantime, Mr. R.K. Talukdar, learned standing counsel for the respondent, AG shall obtain instruction as to whether payslip was issued to the petitioner while he was serving as gazetted officer.
Paragraph 14.
May I please?
The secretary has directed, asked me to take some time, just a week's time, he's looking into the claims. Claim
Affidavit has not been filed.
No, well, instructions can do because he has a claim for medical reimbursement. That proposal has been found at the office of the secretary.
As per last order, my lord, status.
It was last received in the office of the secretary and of the department in 2020. After that, what happened to that proposal? Was there any payment has been done or process that we are looking into it?
Okay. Heard.
Short maybe.
Heard Mr. A. Hussain, learned counsel for the petitioner, Mr. Gogoi for respondent in
Forest Department.
Forest Department. Mr. Gogoi, Health Department. Miss, your name, please? Mr. Gogoi, learned standing counsel for the Forest Department, pressed for listing the matter after a week so as to enable him to obtain up-to-date instruction. Where allowed, presses and list the matter on 10th of December.
My lord, kindly have a look on the 17th September 2025 order, my lord. 17-9.
Yes.
Then my lord, another order on 17-10-25. No. Counsel. Also put a very short time in this matter. Gradation list con.
Yes, whether the instructions are available.
The only question involved matter would that be this has been filed, my lord, but they have kept my promotion in the seal cover. Absolutely, this honorable court as a honorable apex court has the findings on this point. You cannot keep the promotion seal cover until and unless, my lord, it has been filed. But admittedly, no charge sheet has been filed. In the departmental proceeding, I am been acquitted, my lord. So this instruction, honorable court.
Departmental proceeding, you have been acquitted.
Yes, my lord. But this honorable court has directed whether any charge sheet has been filed or not. This instruction is to before this court. They have kept my promotion under seal cover. What is this honorable court? My lord, my grievance.
So are you really interested to file the affidavit?
One thing is not clear, my lord, who is the authority's draft gradation list? Either the PCC of Assam or the BTG authority.
Page number?
49.
Yeah.
9, my lord.
Number 5, my lord.
No, sir.
Who prepared this?
Authority of this. Heading should be there. Then we can. Who is to take notice and who is to respond?
No, Mr. Gogoi, you say notice has been issued to you.
No.
You have received a copy.
But our.
You have obtained instruction who prepared this.
Yes, ma'am.
Yes, my lord.
But they can give the heading letter also, it will make things easy for them also. There will be a head letter. Covering letter will be there. How?
Where,
circular
Mr. Deka,
guided way.
from where you obtained it? This letter?
Yes, petitioner has provided,
The petitioner also can further.
But
provide
who
the
prepared it?
letter.
my lord.
Who had prepared it? Who is
Yes,
authority
at
has
least
prepared?
we can take instruction of this one.
Okay. Ms. Bora submits that the instructions are still awaited. Accordingly, it is provided that Ms. Bora shall obtain the instruction after, okay, fine. Obtain instruction and apprise this court on 8th of December. Further, it is clarified that no opportunity will be afforded to Ms. Bora to obtain instruction. In the meantime, Mr. Deka, learned counsel for the petitioner, shall also obtain instruction as to who had prepared the Annexure 8.
Annexure 8.
List the matter on 8th December.
Achha, we have received affidavit in operation today itself. I wish to file a reply.
Heard, Mr.
BS Declaration.
Learned counsel for the petitioner and Mr. PP Dotto, Learned Standing Counsel for the respondent, APSA. The Learned Counsel for the petitioner submits that he has received the copy of the affidavit in opposition filed by the respondent, APSA, and he may be granted some time to file his reply to the aforementioned affidavit in opposition. Bear allowed. Recessal is the matter after 1 week.
Date may fix for.
Okay.
10 December.
Item 36, order matter.
So this writ petitioner office, he was appointed as a principal in September 2024.
Okay.
And I'm going to retire in January 2026. Only 2 months lost. But still I am not getting my principal title. I have in my writ petition, I have prayed for pay protection and other notional benefits. But even also the pay scale attached to the post of principal has not been given to me.
Lordship, on the last day, Lordship, my London friend had submitted that the proposal was sent to the finance department. And the communication was supposed to be given to me. She had, like, the communication was handed over to me today. I have confirmed with the department, Lordship, here, Lordship, the proposal that was sent, the checklist, there are certain anomalies in the proposal that was sent, and the department has telephonically informed me that they're going to send the proposal back to the the education department to complete the other formalities. Lordship, the release order, as per my instruction, the release order that was sent by the education department was not legible. And the checklist, which was sent by the department, it lacked the signatures of the authorized authority. Lordship, it was signed by the DEO, but someone from the, oh sorry, Lordship, it was signed by the inspector of schools. It needed to be signed by somebody from the department, from the government, basically. So Lordship may grant us some more time. I'll produce a.
No, but say the petitioner will be retiring in the month of January.
January.
Yeah.
Lordship, here, Lordship, I'm only seeking 3 weeks time, and all the benefits, Lordship, as the matter is in front of your Lordship. So, whatever the petitioner will be entitled to, that will be given, Lordship. We are not disputing.
No, the question is why she has to approach this court for getting her legally entitled benefit.
Lordship, yes, there was a representation filed on 25th to the, now Lordship, the file is moving, Lordship, as per, so.
File is moving, but they have sent a file to you. You are sending it again back to them.
Lordship, no. We have to go by the record and all. We have to ensure.
No, that's all right.
If something happens, Lordship, we'll be blamed later on. Lordship, we are just making sure that all the.
Then how the department has forwarded the file to the finance department?
Obtaining necessary sanction from the finance department.
No, that's all right. The finance sanction is necessary. But why the incomplete file was forwarded?
If Lordship, that.
Lordship, my instruction is that written instructions are awaited, but verbal instruction itself, the file has come back from the finance department to ask you, Lordship, today it was sent to ask you. So Lordship, give us a 2 weeks time, Lordship, if there are certain anomalies as said by we will rectify it,
Lordship,
2 weeks.
it was a short date, Lordship. In the meantime, Lordship, logic, we'll bring it to a logical manner. Only, Lordship, these are formalities because we have to.
No, that's all right. But this petition was filed in the month of
25 only, Lordship.
maybe.
Representation was filed in the month of May, Lordship, if I'm not.
Okay. Heard Mr. Eskedas, Learned Counsel for the petitioner. Mr. Soliha for the respondent in finance department. Ms. Musahari for the respondent in secondary education department. Mr. Soliha submits that though the finance department has received the file, but the same was not, but the checklist, but the file was forwarded without proper checklist and also without the signature of the department. Authorized person of the department, but under the signature of the inspector of school. And as soon as the file is received back from the department. The finance department will accord concurrence, and he pressed for listing the matter after 3 weeks. Ms. Mosari also submits that the file has been received back by the department today itself, and they will take necessary step to forward the same again to the finance department after completing all the formalities within a period of 2 weeks from today. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that SSL lays the matter on
17 December.
sorted
17 December will be too.
10 December.
10th of December.
Can it be in the first week of, because there will be vacation, there will be again vacation.
No.
My learned friend and we are both applying for the government lordship. In the meantime, that much time lordship, we'll place our instruction. It is not like only the education department. If the proposal is spent towards all the necessary documents, lordship, on 10th of December itself, we can come up with a concrete.
Okay, 10th of December.
And also with regard to my other prayer for notional benefit from 2017, I am seeking. I also annexed 2 orders passed by the honorable government under similar circumstances. In that case, also they have not filed any affidavit to that. This is for only the post of principle. With regard to the notional benefit, they have not come up with any instruction.
Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that SSL lays the matter on 10th of December. And in the meantime, the respondent authorities shall complete all the formalities and also obtain instruction in respect of extending the notional benefit of pay to the petitioner from the date of her appointment.
Because I was deprived in 2017, I was appointed in 2024. The last man who was appointed in 2017, I am seeking notional benefit from 2017. 25,2007.
In respect of extending the financial benefit to the petitioner with effect from 2017. List the matter on 10th.
Bailey, 17. In this case, I have received the report, madam, notice. Notice already served.
Notice served. But no one appears. No one appears. Heard Miss Mazhar Bhuiya, learned counsel for the
Lordship,
applicant.
Lordship, in this matter, amicus may be appointed for.
Yes. And also heard Mr. Bortakur, learned additional PP for the state respondent. Mr. Bortakur submits that he has received instruction, and as per his instruction, notice has been served upon the respondent number 2. But it appears that, where is the report, Mr. Bortakur? Mr. Bortakur has also produced the report of service of notice upon respondent number 2. It appears that the notice upon the respondent number 2 was served on 12/11/2025, but the respondent number 2 remained unrepresented today, and accordingly, who can be appointed? Suggest the name who is a regular in the court.
Yes, no.
Who?
Yes, no.
He does not
Radio. Oh. Accordingly, it is provided that Restisel engage Srimati Pooja Agarwal as the legal aid counsel. As amicus curiae to represent the case of the respondent number 2. Recessal reflect the name of Srimati Agarwal in the cause list and also furnish relevant papers to her well in advance. List the matter on sorted this month.
Item 18 for orders. Order Mitch.
May. Kindly see the last order, my lord.
Mr. Sharma?
Lawsuit.
Yeah, up to date in
Verifying instruction lawsuit. That proposal which was sent by the director has been received by the secretary. It is under process for approval from the minister and thereafter endorsement to the finance department for concurrence and for creation of post. So it will take some time. That proposal they have received.
When you have received it?
That date they did not confirm me. That proposal was dated 17th October 2025. They received that proposal and it is under process, I'm told by the deputy secretary today. And it is under process. Once the approval from the minister is taken, then it will be endorsed to the finance department for concurrence as well as the creation of the post. So it will take some time. Otherwise, Lordship, here, director is the sole content master. And director, as per the order of this report, director has already complied.
No, until and unless the appointment letter is issued, we will not close the petition. You ensure it. Heard Mr. Islam, learned counsel for the petitioner. Mr. P. N. Sharma, learned standing counsel for the respondent, contender. Mr. Sharma, on instruction submits that the department has received the proposal from the director and after according sanction to the proposal, the department will forward the same to the finance department for concurrence and thereafter a post will be created and it may take some times and a press for listing the matter after.
After 4 weeks.
No, 4 weeks.
Because it will again go to finance and.
No, you expedite the process. This is of 2024 matter.
Yes, my lord. Same prayer also met earlier, my lord.
You expedite the matter. We'll fix after 3 weeks. Okay.
On 9.
Obliged.
Item 19.
Make the children. New order has been complied with.
Complied. Complied.
Payment has been reviewed.
Appointment has been issued. All right. Heard Mr. Islam, learned counsel for the petitioner. Mr. U. Sharma, learned standing counsel, learned counsel for the contender number 1, Mr. Soliha, and also Mr. Soliha for the finance department. During the course of deliberation, Mr. Islam submits that the order of this court has been complied with by the contenders. And Mr. U. Sharma, learned counsel for the respondent number 1 has produced the advice slip given to the treasury and to the branch manager and also the memorandum of payment by treasury officer. Accordingly, taking note of the submission of learned counsel for both the parties, this contempt petition stands closed.
Respondent number 2 also, on behalf of Bigos.
On respondent number 2, okay, close.
Obliged.
Item 20.
This is last occasion, my lord.
In this matter, I have inspection and department moved the file into the judicial department for fetching error.
Rating or opinion?
Minutes of.
Rating or opinion?
Rating of the minutes of the SLC meeting. By file number so and so. After getting the better, the minutes will be sent to other members of the SLC for their signature who are present in the meeting.
So what is the outcome?
Minus, after vetting or after signature of this member, then minus it will come.
No,
Lordship,
no, what
meeting
is
was
the
held on
outcome?
31st October, Lordship. Already 18 days get, already 18 days gets goes, Lordship. All this time, there must be signature of the members, Lordship. They have written this letter on 18/11/25.
2 weeks may be granted so that I can get the minus, my lord. After signature of.
No,
this
no, what
member.
is the outcome?
My lord, regarding the outcome, my lord, here it is not mentioned, my lord, and in the minus itself, my lord, all the outcome is contained, my lord. The result of the candidates are our content.
Pardon?
My lord, the result of the candidate has contained in the minus, my lord, minus itself. And minus is now in betting, my lord.
Okay.
On the
Heard
judicial
Mr. P.
department.
Sharma, learned counsel for the petitioner. Mr. U. Sharma, learned standing, no, learned counsel for the contender. Mr. Sharma has produced one letter of the Joint Secretary to the Gupta Basab dated 18/11/2025 and submits that the minutes of the meeting of the SLC has been forwarded to the Judicial Department for vetting.
Yes.
And he pressed for listening the matter after 2 weeks. However, Mr. Sharma is granted 10 days time to apprise this court about the status of the concerned file. And recess the matter on
2nd December.
2nd of December. The letter produced before the court today shall be marked as Annexure A and be taken to the record.
Please, your lordship. Here, this case, my lord, notice was issued in 2016 in content, but respondent filed a review.
Respondent?
File review of the order.
Okay.
So both the case, my lord, tagged, and in 2023, the review was dismissed.
Okay.
Then after that, my this content matter has been listed. My lord, we have no instruction on what happened, whether the order is complied or not, because it is a case of 2016.
Okay.
So
Okay.
sometime, like 2 weeks time may be given now.
The learned counsel for the petitioner submits that the respondent authorities have preferred one review petition against the judgment. Review petition being review petition number 78 of 2016 against the judgment and order of this court dated
50.
12/5/15 in WPC number 3165 of 2010. And the said review petition has already been dismissed by this court in the year
My lord, by order dated 26/2023.
26/12/23.
26/2023. 26/2023.
And he may be granted some time to obtain instruction as to whether the order has been complied with or not. Here alone, races are less the matter. After 1 week,
Mine.
okay, list that, fix it.
On third.
Hard disk, applies.
Item 22.
Lordship, Lordship, would kindly peruse the last order of this honorable court dated 11/2025.
Yes, Mr. Devi? Furnish a copy to her.
Yes.
You obtain instruction.
Lordship.
So we'll list the matter on next Monday.
Lordship. Till now, they have not received any amount.
Has already been furnished to her.
Hmm.
Okay, look.
No, you come to the last part, that amount already paid to be adjusted against this authority. They have already issued the authority. You obtain instruction and apprise this court on next date.
Lordship. As of now, they have not received any amounts, but I'll take the further instructions, Lordship.
Just to, first to with the treasury. Your Lordship.
Treasury.
Yeah.
The copy has been sent to them.
So this letter is of dated 18th, yesterday. So
Yes, sir.
today, it
It
is
is.
impossible.
I will regularly pursuing this, in this, after your Lordship's strict direction last.
Okay, then we will fix in the last part of coming week. On next Friday.
Next Friday.
Next Friday.
Next Friday and date, Lordship.
27th. Oh, sorry, 20.
20th. Or prior to that. 25th. 25th.
20.
You inquire the matter from the Treasury Office.
Lordship.
Have to pursue with them. Solomon.
And you received a copy of this order.
Yes, I have furnished to her.
I have received it
Okay.
just now, Lordship.
You forwarded a copy, forwarded to the
Treasury.
petitioner.
Lordship, I'll do so.
Third Miss,
D. Mohanto, Lordship.
learned counsel for the petitioner.
Sir, for expeditious redressal, counsel for the treasury who represents, if he is also, if it coordinates, then it becomes easy. Otherwise, it is troublesome.
Lordship, may kindly direct. Lordship.
Mr.
could-
Solia is not there.
Then it works. Yes, the communication is.
Finance, Soliha,
Purpose.
Soliha.
আপোনালোকে তেখেতৰ লগত coordinate কৰিব।
Lordship.
নহ'লে বহুত troublesome matter।
During the course of deliberation, Mr. Soliha, oh, no, sorry, Mr. Deori has produced a letter dated 18/7/2025 and submits that the order of this court has been complied with and the authority has been issued in respect of special family pension of the petitioner. Mr. Soliha, so this copy has been sent to the Treasury Officer, Nalbari.
Yes.
You ensure payment of the amount by next week.
By next week. Lordship.
Week.
Lordship, yes. I give Lordship a copy of the.
কি কলো লাইনটো? Accordingly, Mr. Soliha, learned standing counsel for the Finance Department and who represents the Treasury Officer also, is directed to ensure payment of the amount, payment of the special family pension to the petitioner. and apprise this court about the latest status of the letter dated 18th of November 2025 before this court on 25th.
If I'm furnishing a copy.
Yes, a copy of the letter produced before the court today by Mr. Deori shall be marked as Annexure Z and be tagged with the record, and also a copy of the same be furnished to Mr. Soliha to ensure payment of the family pension to the petitioner. List accordingly. No,
For
like,
6 and 7.
no, like.
Worship, my name may be reflected in the court appearance.
Okay, recess shall reflect the name of Mr. Soliha in the call list or next date.
Lordship, my name is for 6 and 7.
Mr. Deori for 6 and 7.
Item 20.
Highly obliged, Lordship.
But, please, Lordship, the order is not complied, my lord. In the meantime, petitioner already died, my lord.
Okay.
I've taken time to complete the
Legal
legal
hairs.
hairs, my lord. Okay.
And my lord,
As well as, my lord, new incumbents, my lord.
Tom Soikia has also retired from this department, my lord. So, new respondent maybe increased here.
Yes, my lord.
Okay.
Now secretary.
Heard Mr. Guhai, learned counsel for the petitioner, and Mr. U Sharma for the secondary education department. Okay. The learned counsel for the
Elementary, my
petitioner submits that the petitioner has suffered demise during the pendency of this petition, and he prays for granting him some time to implement the legal heirs of the petitioner in this petition. Mr. U Sharma, learned standing counsel for the department, also pointed out that the respondent contender number contender number 1 and 2 already retired from service, and as such, there is a requirement of implementing the present incumbent as respondent contender in this proceeding. Accordingly, it is provided that the learned counsel for the petitioner shall take necessary step for implementing the new incumbents in place of contender number 1 and 2. Place the matter after 2 weeks.
Yes, my lord.
2 weeks.
But this method is pertain to elementary education. So my lord, Narayanpur, the Department of School Education. Secretary Department of School Education. Elementary.
Okay. Secretary, Department of School Education.
Items 24 and 25.
My lord, this contempt petition is the willful violation from salary from October 2007. And during the pendency of the contempt petition, my lord, the petitioner received a copy of the appointment letter in respect of tutor. That was not till today not challenged. Better close and in the matter, liberty may be given if they challenge this, the particular condition of the appointment letter, they may be advised.
Both the matter.
No, only 24 in respect of me, my lord.
25 same, my lord.
More
25 same, my lord.
contempt may be closed and liberty may be, yes, so advise this if he challenge that from tutor, my lord.
Okay. Heard Mr. N. Bora, learned counsel for the petitioner. Mr. U Sharma for the department.
My lord, the respondent number 1 is already retired matter. Also, new incumbents.
No, we are closing the matter.
Closing.
Yes.
During the course of hearing, Mr. Bora submits that during the pendency of this petition, the petitioner has been appointed as tutor by the contender
With a prospective effect, my lord.
with a prospective effect. And as such, this contempt petition may be closed, granting liberty to the petitioner to challenge the appointment letter.
Yes, ma'am, that
Appointment letter
condition, my lord.
to challenge the appointment of the petitioner as tutor.
My lord.
As tutor. Pair allowed, taking note of the submission of Mr. Bora, learned counsel for the petitioner, this contempt petition stands closed. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition challenging the condition laid down in his appointment letter as tutor.
This liberty is not required, my lord.
No, we don't require.
No.
That
Liberty
appointment
to
letter,
file
Tutor,
liberty to challenge his appointment as tutor
tutor, much less.
in
I am again, we have got appointment number 2 and 1, my lord.
2 and 1. Yes, Mr. Gohai, this matter, next matter is same.
Same match.
Okay,
Much less.
same.
Ajam 28.
Well, very fails the last order date 15/10/2025.
For item 28, Mr. Continue is on the deck in court number 1. Can it be taken after some time?
But we don't have mass matter.
Only 4 weeks.
Okay.
29.
In this case, earlier, my lord, earlier incumbent was retired. So that is why we were directed to inflict the new incumbent. Accordingly, that order was, my lord, passed. Now we are to submit the, my lord, amended cost title. So, my lord, I am recently engaged. Actually, I could not go through the record. So that is why today I have seen only. In between, my lord, some development is there. Development is that, my lord. Earlier, the direction was that to regularize the service of the petitioner and to give him the benefit since his date of joining. But what happened, my lord, during pendency of this content petition, he retired. And so, and thereafter, they have taken a, my lord, cabinet decision, and cabinet decision was that prospective who are still in service, there are some other petitioner in other connected with petition. So who are still in service, they will get the benefit, and who already retired, they will not get anything. So, my lord, order was there that the persons who their appointment were genuine, so they will get the benefit since the date of their joining. So now themselves, they have preferred an appeal also. Division bench dismissed the appeal. Thereafter, they themselves, my lord, in cabinet took a decision. The person who already retired, they will not get anything. So petitioner is one of them. Lordship has seen the order, perhaps, my lord. So, my lord, this is the violation of this order, my lord, that direction. Second violation, my lord.
That's all right. First, you bring on record those
My lord.
new incumbents.
My lord.
Thereafter, we will say.
Yes, my lord.
Yes.
Pardon?
Their notice was issued,
Yes, madam.
but no stay was granted.
Yes, ma'am. There shall be a stay of.
Okay,
order
there shall be stay.
in one.
Similar matter means not this order. In this or in this.
Not
case.
this order.
But all those matters are similar.
Maybe. But unless the order passed in the writ petition is not challenged before the Supreme Court, there is no stay in respect of the order. Heard, Mr.
N.K. Kolita.
Kolita, learned counsel for the petitioner, and Ms. Bukon, learned counsel for the contender. Mr. Kolita submits that during the pendency of this petition, the contender number
I
One-
feel
one-
210 was there.
one was contender number 1 already retired from service, and As such, he may be granted some time to implement the new incumbent in place of the contempt number.
Amended cost title only. Amendment already allowed, my lord. So we
Later
were,
on, Mr. Kolita submits that the pair of the petitioner to implement the new incumbent has already been allowed, and the matter is pending only for submitting the
amended cost title.
only for filing the amended cost title. And he pays for granting some time as he has recently been engaged in this matter. Pair is allowed, rest is a leisure matter after 1 week. After 1 week.
May I take that, my lord, the order copy, my lord? Obliged.
My lord, very unfortunate situation, my lord. There is a specific direction by this honorable court. At two times they passed the order. Again and again they rejected, and thereafter honorable court specific direction to given to the parity of the same my lord similar list. Petitioner may be also entitled, my lord. Thereafter, my lord, due to contempt, save the contempt, they given the one appointment letter, my lord, without giving any salary, without completely violation of the honorable court orders, my lord. Please may kindly see the order, my lord. Page 35, my lord. Page 35. Join her position not a question, my lord. That is given the only lollipop, my lord. Nothing salary has also not been given. Please may kindly see the order, my lord. Page, my lord, 33, my lord. The order has been passed, my lord. And 28th annexer, 17/3/2022, my lord. And turn into operative portion, my lord. Page 35, my lord. Start from 34, my lord, serial number 12, may I read, my lord? 34, my lord, page number. Resultant thereof, the order impugned dated 31/10/2018 has been passed. Upon perusal of the order so and so, it is noticeable that the commissioner secretary had endeavored to make an independent assessment on the claim of the petitioner without being itself to the requirement to the judgment dated so and so. The commissioner secretary went to the question that the recommendation of the expert committee, the petitioner was in a category where she was recommended not for any kind of regulation of salary. Secondly, commissioner secretary to again goes back to the question that petitioner appointed against a non-existing post. This is the important matter. When there is an effective adjudication by this court that petitioner is entitled to parity with 33 other teachers appointed pursuant to the select list dated 5/3/2001, and such judgment having arrived at its finality, madam. The commissioner and secretary is bound to confine its consideration to the said aspect and not to venture out to make a de novo independent decision on the subject. From such point of view, the commissioner and secretary did not have jurisdiction and authentication of the law to again go back to the question on the recommendation of expert committee in respect of petitioner. Accordingly, rejected her claim. What is noticeable is that the commissioner had not even considered the conclusion of this court that petitioner is entitled to parity with 33 of the assistant teachers who were appointed pursuant to the select list dated 5/3/2001. And that parity means that her service is to be regularized by creating a supernumerary post by giving benefit effect from 1/9/2004. The second reason of the commissioner secretary petitioner appointed against non-exist force, the same was also decided by the court by the judgment and order dated so and so, that it is the petitioner who was appointed prior existing vacant post. Therefore, appointment cannot be constituted to be against any non-existent post. The conclusion of the commissioner secretary appeared to conflict with the judgment of this court dated 5/9/2017. For the reasons stated above, the order of the commissioner and secretary dated so and so is set aside. The matter against remanded back to the principal secretary to pass a fresh order strictly taking note of the conclusion already arrived at by this court, the judgment dated 5/9/2017, in which WPC number so and so, which has already been referred herewith, it clear and certain terms, the requirement of the past within a period of 1 month, my lord. Thereafter, my lord, contempt petition was filed, my lord, and thereafter, my lord, they, my lord, please may kindly see the affidavit opposition filed by the, my lord, respondent, sole respondent, my lord, and give a order, my lord, page 50, my lord. Page 50. Your lordship got it, my lord? Page 50. Order dated, my lord. 7/5/2025, my lord. May I read, my lord? Second, finding second para, my lord. In view of above, this department has duly examined the matter, taking note of the conclusion already arrived at by this court, judgment and order dated 5/9/2017 in WPC number so and so, order dated 17/3/2022, passed in WPC number so and so, had concluded that present petitioner, Dipti Das, is also entitled to claim parity with the relief that granted to the other teachers appointed pursuant to similarly so and so. Their service were regularized by creation of supernumerary posts as per order dated 30/12/2006 with effect from 1/9/2004, and that it was the petitioner who was appointed prior against a vacant post which she was appointed, but subsequently when she was sent to the junior basic training course, another incumbent was appointed to the same post. Therefore, now compliance of the Honorable High Court's order petitioner was heard in person so and so, the office chamber, understand and conclusion arrived at by this Honorable High Court have been taken into consideration. Accordingly, it is held that petitioner Dipti Das is also entitled to be regularized by creation of supernumerary post, and department has sought to concur finance department so and so. This order has been passed by the secretary. Thereafter, my lord, please may kindly see the page 52, my lord. Page 52, my lord. Lordship, my lord. In pursuant to government letter number so and so dated so, in compliance to Honorable High Court order dated so and so, the service Dipti Das petitioner contempt so hereby regularized with effect from 1/9/2004 to till occurring the vacant post and subsequently adjusted stipendary teacher 1,800 per month against a regular vacancy assistant teacher under BO Lakhimpur, my lord. Now, my lord, they have creating 1,800 per month, my lord. Whereas same, my lord, same selected, please, my in my reply, my lord. Order was, my lord. But thereafter, they came before the now division bench. Division bench also dismissed their writ appeal, my lord. That was also annexed page 66 annex 5, and your lordship go to the, my lord, page 75. Same 32 select list, others were given by lord scale of pay.
No, there is no page number 75 here. When did you file?
6 and 7, my lord. Annexure 7 of my reply, my lord. Your lordship got a reply? My reply, my lord.
No, no, your reply is not here.
Other 33 persons were regularized with effect from 1/9/2004 by giving all scale of pay, my lord. Now petitioner, my lord, is only given, nothing given, just order has been passed 1,800 per month with effect for 2004, and thereafter she joined 3 months already left, they even not even a salary also not given, my lord. Clear violation of the two orders, my lord, by this honorable court, my lord, 2 orders, my lord. Your lordship got my reply?
No, it is not available.
Your lordship, this is the account video of that. Similar seated persons are given from 2020 to 2004 by scale of pay, my lord. Your lord, honorable court directs specifically direction that they should be given, my lord, parity with effect from 2000 by giving the scale of pay. Because of that, they completed basic training 2004.
No, no. Here also the order is given effect from 1/9/2004.
1800 per month, how my lord, we are completed basic training from
No, no.
2004. This is the 33 petitioner already given with effect for 2004 is the scale of pay, my lord.
You have completed your basic training in the year
2004.
2004.
That 33 petitioner is also 2004. They are given honorable court specifically this that the parity with entitled that similar situation 33 teachers, my lord. And Commissioner Secretary has also given the findings that they are she is given to effect for 2004 scale of pay. But director is his own mind, my lord. Two judgments are there. First, my lord Justice is C.K. Roy, and thereafter my lord Justice Bujor Bora sir. They specifically stated we cannot go beyond my lord is independent way, my lord. And they given only order with effect for 2004 1800. In spite of his my lord appointment and joining, they did not given any my lord salary also.
Yes, Mr.
Totally violation of the court's order.
Okay, okay. But your affidavit is not available on the record, Kobe. Right. When did you file this affidavit?
কেতিয়া দিছে প্ৰথম মোৰ তাত দি দিছো যে
So, Mr. Bora, say director, from where the director got authority to grant her only stipend at the rate of rupees 1800 per month?
Regarding this, I take instruction. Other thing is that
No, you obtain instruction and apprise this court on Monday. Otherwise, we will issue notice.
my lord.
This is a fit case for issuance of notice. We will issue notice.
on Friday, next Friday.
Friday, okay.
Not this Friday, but like.
No, no, no.
My lord, Monday is better. Monday, my lord.
Monday. Heard. Mr. Bora, learned counsel for the petitioner. And Mr. P.K. Bora, learned counsel for the contender. Mr. Bora submits that he has already filed an affidavit on submits that on 28 October 2025. He has filed one reply to the affidavit filed by the contender, but it appears from the record that the same is not tagged with the record. Accordingly, it is provided that SSL is the matter on Monday by tagging the affidavit in reply filed by the petitioner with the record. Further, drawing the attention of this court to the order dated 18th of August 2025, Mr. Bora submits that in spite of observation made by the Commissioner and Secretary to the Governor of Assam in the order dated page number
50, my lord.
50.
Their affidavit, my lord.
Page number 50 of the affidavit filed by the contender. Mr. Bora submits that the petitioner Dipti Das is entitled to be regularized by creation of a supernumerary post. Hence, the department has sought concurrence of Finance Department for creation of supernumerary post in respect of the petitioner Dipti Das. And in spite of such observation being made by the Secretary to the government of Assam, the contender, in total violation of the order being passed by this court, has issued the order dated 18th of August 2025, extending only the fixed stipend of rupees 1,800 per month for the period 1/9/2004 to 31/12/2016. And as such, Mr. Bora submits that the order being passed by this court is violated willfully by the contender. At this basis, Mr. Bora submits that he may be granted some time to obtain instruction as to why the stipend of fixed stipend of rupees 1,800 is given to the petitioner. By the order dated 18th of August 2025.
8th of August.
8th of August 2025. Pair allowed, list the matter on Monday. Mr. Bora shall obtain necessary instruction and apprise this court on that day. Okay.
Matule.
Right, Your Lordship.
So the SFC is forward secretary, but we need some time because we have to take the final decision. We step out. For creation of the post.
Proposal has been forwarded to
For the secretary,
by the director.
by the director. Finance of the SFC.
Comment. Okay.
Then court takes the letter.
No,
Yeah, we have to take.
the letter has, a proposal has already been sent on 3rd of November 2025.
Coordination is going on between the finance, some time may be required now.
What is going on?
Coordination is going on between finance and the department.
No, the question is whether you have forwarded the proposal to the finance department or not.
We need some time, madam. Already forwarded, but. Yes,
By
sir.
which letter you have forwarded?
Well, other thing is that, well, as part of the scheme is required, it is for PSNB post.
You obtain it.
No, madam, we are processing, madam. That is why I am seeking proof. Madam.
Heard Mr. Laskar, learned counsel for the petitioner, and Mr. Bora for the contender. Mr. Bora submits that. The resolution of the SLC has already been communicated to the secretary to the Government of Assam, Department of School Education, and the same has been forwarded to the Finance Department, and concurrence is awaited, and he plays for listing the matter after 1 week.
No, madam, 2 weeks required. Madam.
After 2 weeks, pair allowed, recess shall list the matter on
8 December.
8 December.
Item 33.
May I put it? So over here, also the state respondent is supposed to file affidavit on the basis of instruction they received last official notice. They have not filed the affidavit. The elementary department.
Service completed.
Service received so far, the response number 6 was already, let's say, they have accepted. And the response number 5, also, I have not received back the acknowledgement received. So far, the dusty service. And regarding the registered post, already have taken. There is office no lordship.
In both 5 and 6.
6 is also they have accepted. SSA, the official respondent. 6 is official respondent. Let's say, in spite of that, let's say, although they appeared, I have taken the registered steps also. But they appear, but so far the response number 5, registered step is taken, and dusty service also taken, but I have not received back the.
By which order?
Dear Lordship, kindly see.
Which note?
23rd of November.
No. You were referring to office note. Who is that? Office note of who is that?
There is office note. I have not taken date, Lordship. Office note is there.
Fiber. This paper said 18. No affidavit.
6. 5 or 6 of it. No affidavit.
No, no, এইটো ষ্টেফে ল'লে চাৰ্ভিচ যে ঘূৰি আহিলে ক'ত সেইটো?
এইটো আহে no affidavit লৈছে।
No, no, এইটো in respect of Dusty service.
অহা নাই। এইটো এইটো আগতো নাই। এইবিলাক আগৰ notice issue নহয়।
For restaurant number 5 is concerned, service is not complete, although I have taken stay. But so for restaurant number 6, Lordship, already they have taken, or sorry, appeared, Lordship, name is also
Okay.
reflected.
Heard Mr. Decker, learned counsel for the petitioner. None appears for the respondent number.
5. So elementary কি? Elementary is there.
None appears for the respondent number 1, 2, 3, 4. 3 and 4. 3 and 4. Mr. Decker submits that notice upon respondent number 6 has already been effected, and the standing counsel for the respondent number 6 also appeared on last date.
The standing counsel of SSA Lordship. Is there SSA নহয় জানো?
Why only limited number?
SSA নহয় জানো?
If the education department,
Nani is appear for the education department Lordship.
if Fupan was here, my lord, prepared.
And Mr. Bora for SSA, respondent number 6.
6.
Respondent number 6. From the office note and also from the order dated 3/11/2025, it appears that service upon respondent number 5 is yet to be completed. You have served a copy upon respondent number 5.
I have taken the dusty service from the registry and it is sent to my client, but thereafter Lordship, I have to receive the acknowledgement receipt, whether it
Okay.
is notice, and thereafter I have
Okay.
to file affidavit. That affidavit I have
Mr.
not
Bora
filed.
commits that in respect of effecting service upon respondent number 5.
Registered
Respondent
step
number
taken.
5, the instructions are still awaited and a press for listing the matter after a week.
Your Lordship. But the affidavit.
After a week or?
After a week, Lordship.
After a week. Mr. Khatoniar, you are for the elementary education department.
To fail.
Okay. Later on, Mr. Khatoniar
Last week, then
appeared for the respondent number 1, 2, 3, and 4. 3 and 4. Recess list the matter after 1 week? 1 week or 2 week?
After 1 week. Supposed to file affidavit because last occasion your Lordship given the direction to file affidavit because they stated that they have received the instruction. But you kindly see your Lordship's last order, 3rd of.
Mr. Khatoniar, when you are going to file
The issue is very simple, Lordship. In chargeship order, ignoring the seniority of the charge, the junior most teacher is allowed to hold the charge. I am appointed in the 2012, so for S105, 2013. Very small.
Okay. Okay. Mr. Khatoniar submits that he may be granted 10 days time to file the affidavit in opposition. Pair allowed, recess list the matter after 10 days. I go to 10 days for 10 days. Mr. Bora, you are not supposed to file affidavit here.
Here 1 to 4.
Only the
Elementary department.
Okay. 10 days.
That's but after 10 days, date may be after 10 days. But the interim order that will be continued.
Interim order pass days will continue.
Oblige.
Here, my lord, their claim is under process, my lord. We have already submitted a supplementary budget proposal because the amount is very high. Right now, the department has not sufficient budget, my lord. So we have approved the government for supplementary budget. It's the instruction, my lord. It will take some time, my lord, but if it's proceeding in the right direction. direction and they will get the amount, but it will take some time. But it is not available.
What is the amount?
Total amount. $95,23,000. $95,28,383. The first page is not to mention, but the second page. Second page is something to mention. Okay, please, I do. What's what you do?
Yes, Mr. Islam, wait for some time.
Yes, that's better because the ultimately.
Heard Mr. R. Islam, learned counsel for the petitioner, and Mr. Khatonier, learned counsel for the contender. Mr. Khatonier has produced 2 letters of the Joint Director of Elementary Education, Kailipara, dated 18 November 2025. And on the basis of the said 2 letters, Mr. Khatonier submits that the things are moving in right direction, and that the department has not sufficient fund. Department or the directorate?
Directorate.
The directorate has not sufficient fund, and the amount is about 95 lakhs 28,383 rupees, and as such supplementary budget proposal has already been forwarded to the department. And Mr. Khatonier, press for listing the matter after
4 weeks.
after 4 weeks. After 4 weeks. The letters produced before the court today shall be marked as Annex A and B and be taken to the record list after 4 weeks.
Date may be fixed up.
8 January 27.
Much.